Yes.
May I please, Lordship? Lordship, I need to mention item number 21. Here on the last occasion, we have given the last chance. But I had a meeting with the department last week also. The concerned officer is on leave. So 2 weeks time will be granted. So as to enable us to file a affidavit in opposition. And I have taken the concern of the other party also.
Both sides are represented. In the prayer made by Learned Additional Advocate General, the matter stands adjourned to enable him to obtain to enable the state to file an affidavit in opposition. Next para. It has been submitted that although today was the last chance to file the affidavit, but the concerned official is on leave, for which the prayer for adjournment is made. Stop. Considering the above, the prayer for adjournment is allowed. List after
2 weeks.
give a date after 2 weeks. Yes.
It'll be on 16 or 19, Lordship.
19. Lordship.
Lordship, I'm appearing for private respondent.
You said all sides. All sides are represented. Yes.
Lordship, I beg to mention
Please,
item,
button up your
hearing
phone.
item number 26.
We don't see you unless you button up your coat.
Lordship, I beg to mention item number 26, hearing item number 26. Lordship, my senior is unable to appear due to unavoidable circumstances. Kindly let the matter be fixed on Tuesday, coming Tuesday.
Both sides are represented on the prayer made by learned counsel to the petitioner. List after a week.
No objection.
Much obliged.
May I please, Your Lordship, I beg to mention item number 90. Lordship, if we may be granted a week's time to file our reply.
You've taken a lot of adjournments. You've taken a lot of adjournments. If both sides are represented, one last opportunity is granted to the petitioner to file his reply. List after 2 weeks.
Lordship, I beg to mention item number 18, Lordship, on behalf of my colleague. Lordship, if 3 weeks' time is granted to me, Lordship, to file my affidavit in opposition.
But you have taken a lot of adjournments. Then, is the state interested to file a reply? Are you contesting it seriously?
Lordship,
Does the state want to contest it, the matter?
yes, Lordship, Lordship, not in this matter, Lordship. I'm appearing on behalf of my colleague.
Item 18, just records of item. Both sides are represented on behalf of the state respondents, prayer for adjournment is made to file affidavit in opposition in the matter. Next, as the case of the petitioner is that he was, she was superannuated without her service being regularized and without making payment of her pensionary benefits. It is made clear that if the state does not file affidavit in opposition within the next date of listing, the state is put to notice that the court may invoke the doctrine of non-traverse and deem that the state is not contesting the writ petition and has accepted the contention of the petitioner, and appropriate orders would follow. Next paragraph. The learned government advocate shall transmit a downloaded copy of this order to the concerned respondent authority to put them to notice of the order. Next paragraph. List. Give a date after 2 weeks.
Lordship, I also like to mention item 20, Lordship, on behalf of my colleague. I've sent for vetting, so if 1 week time may be granted to me, Lordship.
How much time?
Lordship,
How much time?
1 week.
Okay. Both says are represented. List after a week as prayed for by the learned government advocate.
Much obliged, Lordship.
Please, Lordship. Lordship, I beg to mention item number 11. Which I'll begin a mention on behalf of my senior young warrior for all the respondents. Your Lordship, we have received an instruction, so the affidavit is under preparation. So if 3 weeks time may be allowed to me.
11. Both sides are represented. On behalf of the learned CGSC,
Mano.
a statement has been made that instructions has been received and the affidavit has been sent for vetting and signature. Put stop accordingly. List after 3 weeks.
Obliged.
Please, Lordship. Lordship, if I may be allowed to move an unlisted motion, my lord. This motion is NIA for treatment. This IA is in connection to today's cost list, my lord. Item number 34 in the supplemental cost list.
Okay.
Obliged, my lord.
May I please, Your Lordship, I beg to mention item number 23 in the orders. Here, in the orders, item number 23, Lordship. This is a similar matter with the read ability 23 and 24, which Your Lordship must be aware where my senior has part heard yesterday. And then this is a similar matter where the latest notification, the corrigendum dated 10/4/2026, that notification has become the infrastructure in this instant petition. Therefore, Your Lordship may graciously allow to withdraw this petition and with a permission, with a liberty to file afresh.
Okay. On instructions, Mr.
Lelam Chung Phim Chung, Your Lordship.
Lentong P.M. Chungar. I don't know whether I've spelled it correctly or not. Then learned counsel for the petitioners submits that in the meanwhile, the matter has become infructuous because of subsequent notifications issued. And accordingly, he prays for leave to withdraw this writ petition with liberty to approach again in view of the subsequent development. Next paragraph. Ms. V. Sukri, Learned Additional Advocate General for the state is present. Next paragraph, the matter stands dismissed on withdrawal with liberty as prayed for.
Deeply obliged, my lord.
Mr. Lordship, I beg to mention item 13 and 14, Your Lordship. On behalf of my colleague Nivika, who is appearing for the state, she has received instructions, so she may be allowed 3 weeks time to file counter, Your Lordship, in this matter.
13 and 14.
Yes, 13 and 14, Your Lordship.
13 and 14. Both sides are represented. On behalf of the state, it is submitted that the instructions has been received and accordingly 3 weeks time is prayed to file affidavit in opposition in the matter. It is allowed. But last opportunity is granted to the state to file the affidavit at least 2 days prior to the next date of listing, next list after 3 weeks.
Bless you, Lordship.
May I please, Your Lordship? I beg to mention item number 25. Your Lordship, my senior counsel is out of station, so kindly list the matter after 3 weeks. I have taken the counsel from the counsel for the petitioner.
25, all sides are represented. With consent for the other side, from the petition, from the petitioners learned counsel, prayer for adjournment has been made by the learned counsel for the private respondent.
Private respondent.
So prayer is allowed. List after
3 weeks, Your Lordship.
3 weeks.
Bless you.
Your Lordship, I beg to mention item 7.
We don't see you unless you button up your coat. Button up your coat, otherwise we won't see you. Yes,
I beg to mention item 7. The leading counsel is indisposed. If kindly we granted 2 weeks time.
okay. 7.
Yes.
Okay. Both sides are represented on the prayer made by learned counsel for the petitioner. List after 2 weeks.
Your Lordship, there is an interim.
Interim order passed release stands extended till the next date of listing. Yes.
Your Lordship, I beg to mention item 30, hearing item 35 from supplementary cost list.
Yes, why?
The leading counsel is indisposed.
Okay, you are appearing with the private respondents.
Yes.
Okay.
For respondent 2, 3, 6, and 7.
Okay. All sides, including the London Additional Advocate General for the state, are present. Next one, the prayer made by learned counsel for respondent was 2, 3, 6, and 7. Matter stands adjourned today. List after a week.
Your pledge. This is Lordship. Lordship, I beg to mention item number 10, Lordship. Lordship, here in item 10, the similar matter is pending before the division bench. So Lordship, if this matter can come up after 2 weeks, Lordship.
Okay. 10, both sides are represented on the prayer made by learned counsel for the petitioner. List after 2 weeks.
At your place, Lordship.
Yeah, please, Your Lordship. I'd like to mention item number 24. I pray that 2 weeks time may be granted as my senior is out of station.
You're for the private respondent.
I'm for the private response.
Lordship, if it will come up on 21st as fixed item.
Okay, both sides are represented on the
Lordship.
prayer made by learned counsel for the private respondent. The matter stands adjourned today. Next matter is agreed to by both sides. List on 21/5/2026.
Obliged.
May it please, Your Lordship, I beg to mention item number 33. The leading counsel, who is a standing counsel of Nagaland University.
23.
33, which is fixed for today, Your Lordship.
Yes,
The standing counsel for the Nagaland University will be filing his affidavit today. So 2 weeks time may be granted.
you've taken consent of the other side.
Yes, Your Lordship, I have.
Okay, both sides are represented.
My lord, there's an interim.
Okay. On the prayer made by learned counsel for the respondent number 1, 3 weeks time is granted to the Nagaland University to file their affidavit in opposition in the matter. Next matter, the interim order passed release stands extended till the next date of listing. Next matter, list after 3 weeks.
Obliged, Your Lordship.
Bless me.
Not Mr. Lordship. Lordship, I beg to mention item 15. Kindly grant us 2 weeks time to file our affidavit in reply.
Just give the records of item 15. Both sides are represented. Least after 2 weeks to enable, so as to enable the petitioner to file affidavit in reply in the matter.
So much.
From the supplementary cost list for motion, item number 27.
May I please, my lord? Your lordship, I may be allowed to withdraw the present writ petition with liberty to file offense, your lordship.
You're a young lawyer, we don't want to disappoint you, but even that would not have been allowed.
If we
But-
receive some required documents.
It's okay.
But
We don't want to disappoint you. You get that advantage today.
sure.
Both sides are represented. Upon instructions, Miss. Your name?
Jillian,
Huh?
Ace Jillian.
H. Zillian, learned counsel. Please leave of the court to withdraw this writ petition and to approach again. Prayer is allowed. Matter stand dismissed on withdrawal with liberty as prayed for. Please record his presence, Government.
Your lordship is in the order may be passed on item number 28.
Same order.
Lakshmana.
For motion, item number 29.
Please, Lordship.
We can only issue a notice at this stage. It's a work order of 6 months and 13 to.
But Lordship, if I may be permitted to just place one judgment of this court. Yes, just.
But work has started. We'll have to, there are two things operating against you. Number one, Supreme Court says that for tender matters, if you're dissolving, you go to civil court. No, not Ronak International. There have been many subsequent judgments which says go to civil court to claim compensation.
No,
That's
no,
one.
Lordship, this is not for
And-
compensation. This regarding,
Tender,
yes,
short tender notice without due publicity. So if you are aggrieved,
no. Just the judgment.
yes, we have it.
This order passed in the petition 23 of 2019.
Yes,
Decided not to. But to your Lordship, just a few prayers.
The petitioner is challenging the issuance of the work order dated such and such to the respond number 7 by the chief engineer, here respond number 5 for construction of such and such. Now, last line, on the ground that the same has been issued without any notice inviting tender. That is the case. 3. The respondent in the reply have submitted a notice inviting tender for the above contract work with an estimated cost such and such was not published in any newspaper. That is admitted. Now, para 18, your worship. Para 18. Lordship has got it.
yes.
Para 18. In the case of Vincolota such and such, this court has to decide whether the award for a contract to the respondent number 5 without any NIT being published by the state respondent in any newspaper was liable to be set aside. The NIT has been posted in notice board, same case in this, para 19. This court in the award such and such has held that award of contract without publishing the NIT in newspaper was in violation of Rule 2012 rules and the CWD code. This court held at para 29 to 32 as follows. I have already found that in terms of clause 291 of the PWD code, tender notice is to be published in Government Gazette or press or by public notices. Item 13 under the subject tender under head tender agreement and work order in chapter 4 of the rules of 2012 further requires that the tender notice are to be endorsed to all the commissioner, secretary of the department, all major head of department, development department, and notice board. In addition, such tender notice are to be sent to the newspapers for publication. Now, para 31. In fact, those codes and rules are honored more in violation than in observation. A bare also the NIT in question makes us a position very clear. Therefore, there cannot be any escape from the conclusion that in settling the contract in question in favor of private respondent, the department violated all the rules and procedure vis-a-vis settlement of contract. The learned additional AT, however, contends that in the case in hand, the NIT was published in the notice board, same as in this case, and according to him, such publication is a publication as contemplated in clause 291 of PWD code. Such publication also satisfied the requirement of the rules 2012. Unfortunately, such contention hardly meets the specification that in aforesaid codes and rules, and as such, I have no hesitation in rejecting all such arguments. Para 23, Your Worship, 23. In the present case, the NIT was notified only in the notice board as in the present case, as has been done in the case of such and such. Also, 40% of the work has allegedly been done by the respondent number 7, while 70% of the work has been done in the case, in that case. The fact situation is similar in the present case and the above case of such and such, keeping in mind the facts that the contract was awarded without any publication of the NIT in any newspaper or in the mass media, which is against public interest and the interest of public exchequer. The issues of the work order is found to be arbitrary. Accordingly, the work order is such and such as set aside, Your Worship. And this, Your Worship, is exactly my case, Your Worship. Now, in the information which I saw through RTI, Your Worship, they have admitted that yes, it has not been published in the newspaper. It was only displayed in the notice book, just as this, Your Worship.
How do you overcome the Supreme Court orders that even if there is a blatant illegality, you have a right to only claim compensation?
But no, provided I am also a party in that bid, and my bid has been illegally, arbitrarily rejected, Your Worship.
No,
But
it covers everything. It encompasses everything. Every conceived situation can be covered by those orders. Any projects and all those things.
that, Your Worship, in fact, that I am not aware of the decision, Your Worship. But
This is not one. There's plenty of judgments.
I have come across cases where my bid, I have participated in the bid, petitioners have participated, but my bid has been rejected arbitrarily or discriminatorily. Then yes, compensation. Otherwise, this is a case where since no NIT was published, I was not even aware to participate in the bid, in the tender process.
Yes, Mr. Agami, what do you say?
Lordship, the NIT, as far as NIT is concerned, yes, as per the RTI reply, they have published it in the notice board only. However, Your Lordship, the work order was issued in the month of February. Now it is May. The work must have commenced by now, my lord.
I have annexed the photographs, Your Lordship, giving the status of the work. Because since I was not, when I saw some development work going on in the first week of March, I have applied, I have sought information from RTI, Your Lordship, para 5 and 6. I have stated, Your Lordship, para 4 and 5, petition, page 6. RTI on 16th of March, and I was furnished the information only on 14, nearly a month, Your Lordship, 14/4. And I approached this court by way of filing the writ petition on 28th, Your Lordship, on Tuesday. And I've given the photographs of the status, Your Lordship, of the work, the progress. In the cases which I relied upon, Your Lordship, 70%, 40% of the work has been completed, and to the as per the status with photographs, Your Lordship, which I've annexed in hardly 20%, 25% of the work has been completed.
And the estimated cost of the project, your lordship, the work is nearly 10 crore. In my respectful submission, this is a case which calls for interference, otherwise, your lordship, this practice will go on. When there's a rule of 2012 and the PWD code prescribing for the manner in which tender is to be settled, that rule or the procedure ought to be followed.
May I please, my lord, if I may be allowed to make a submission. Lordship, as far as the notice is concerned, the notice may be issued, but with regard to the stay, your lordship. First of all, your lordship, the private respondent who is the contractor here who have got the award, the lordship is not represented today, your lordship. Secondly, your lordship, the work order has been issued in the month of February. It is already more than 2 months now, your lordship. Thirdly, your lordship, even if NIT is floated and then the petitioner did appear before the NIT, there is no guarantee that the petitioner would have got the work. The submission, your lordship, is
Opportunity
that,
of participation,
yes, of course, that I agree, my lord.
then you can also employ people in government service without calling for an advertisement, because somebody will apply and get.
Yes,
There's a remote chance.
lordship, that yes, of course, that-
UPSC has what you call 700,000 openings,
correct,
and lakhs of people appear.
correct,
So hardly any chance of people getting job.
lordship.
Don't do it. Take a resolution. Yeah, it's your own ministry. Take a resolution. The government will never now give any advertisement.
Yes, your lordship, I agree. Your lordship, my last submission will be this, your lordship. This road, your lordship, as your lordship is already aware about this road. Whenever there is a landslide in between in the main national highway, this is the one of the road that connects the Kohima, capital Kohima, Your Lordship. And therefore,
Okay.
and therefore there is an urgency before the monsoon starts. There's an urgency to repair it.
Monsoon has already
Once
set
it's
in.
illegal, it is illegal. If it is not published, then you take the risk.
Having said that, yes, as per the RTI reply, Your Lordship, I agree. I agree. The department have already admitted that.
Heard Mr. T. B. Jamid, and it's counsel for the petitioner, and Mr. N. Angami, learned government advocate, appearing for the state respondent numbers 1, 2, and 3.
No, 1, 2, 3, and 4. Madam.
Oh, 1, 2, and 3 only.
No, 1, 2, 3, and 4 of them.
Okay, 4. Next, brother. The case of the petitioner is that he is a registered class 1 contractor. Now that his firm is a registered class, your firm is registered or you are registered?
The petition, sole proprietor.
Proprietor is registered. Okay, he is registered as a class 1 contractor. And the sole proprietor of firm under the name of Mrs. Roko, ROKO, RINO, Roko Quality Stone, Jotsoma, JOTSOMA. In this case, he is represented by his duly constituted attorney. It is projected that without publication of short notice inviting tender dated 30/2/2026 in any newspaper, a work order dated 26/2/2026 has been issued by the chief engineer, PWD, within bracket RNB, within bracket respondent number 3, which is stated to be in violation of the Nagaland Public Works and Accounts Rules, 2012, and the Nagaland Public Works Department Code. So it is projected that any work exceeding a sum of rupees.
Yeah, there is 5 lakhs, there is central PWD. I'm just relying
Here it's
on
not there.
local folks.
Okay. No, but this requires publication only. Okay. No, just stop there, not required. After the department code, stop. Stop. Referring to the RTI reply of the Office of the Chief Engineer, PWD, RNB, it is stated that in the RTI reply dated 14/4/2026, the concerned public information officer has admitted that tender was published only in the office notice board. Accordingly, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the NIT number which page is that?
29.
29. Just take the tender number from page 29. Tender number so and so, dated 13/2/2026, within bracket annexure E. Issued by the respondent number 3. Insofar as remaining unfinished work is concerned, and for setting aside the said tender with a further prayer for issue of a fresh tender for the remaining unfinished work by publishing the same in the newspapers. Full stop. It is it is submitted that in respect of a similar illegality of non-publication of NIT newspapers, this court in the case of S full stop P full stop N full stop Enterprise versus State of Nagaland and others, within bracket 2020 bracket close 3 GLR 768, had set aside the tender process for publication of the same only in the notice board and not in the newspapers. Next paragraph. Opposing the prayer for interim relief, the learned government advocate, senior government advocate has submitted that the work order in this case was issued on
26.
26/2/2026. And the period of completion of works is 6 months. And therefore it is submitted that by now substantial work may have been done by the respondent number 5 contractor. So it is also submitted that as rainy season would be setting in soon, it is in the public interest to complete the works before the onset of monsoon. It is also submitted that even if the petitioner participates, it's only a question of chance as to whether the petitioner would be settled with the contract. Next paragraph. Issue notice returnable on
Within 2 weeks, Lordship, the arguments, because of the arguments, in 2 weeks.
But how will you serve notice to the respondent?
I may be permitted to take dusty, Your Lordship.
Okay.
Both by registered post and by dusty.
Give a fixed date after 2 weeks. Give a fixed date after 2 weeks. Notice returnable on so and so. Requisite extra copies of the rate petition with all enclosures be provided to the learned senior government advocate in course of the day. Next paragraph. The petitioner shall take steps in course of the day for service of notice on the private respondent number 5 by registered post with AD. Sorry, not registered, make it speed post with AD. Full stop. Moreover, the petitioner shall also serve notice on respondent number 5 by way of dusty after routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next paragraph. In the notice issued by Dusty, the registry shall indicate the next date of appearance. Next paragraph. On a consideration of the prayer made, interim prayer made, having noticed that this court, in the case of SPN Enterprise versus within bracket Supra, had interfered with such tender process, which was only published in the notice board and not published in the newspapers. The court is of the considered opinion that in cases where the tenders are quietly published only in newspapers and by avoiding public notice, the in order to maintain transparency in the tendering process undertaken by the government, this is a fit case for staying forth with all works that is continuing in person to the short notice inviting tender number at page 29, so it's dated 13/2/2026. And work order, issued pursuant to the said tender notice. Next paragraph. The petitioner shall cause service of a certified copy of this order to the office of the respondent number 3, so as to make this order effective on the respondent number 3. Next paragraph. List on
Lordship, I have a small query regarding the steps, Your Lordship, since I have to take custody, if, within, in the course of the day, please do this, Your Lordship.
No, then we'll have to, you see, we are giving a stay.
Oh,
No, do it. Copying will make only 10 minutes time. Protesting will take only 10 minutes time. Take it because we are staying the. He will do it. He looks more competent. He is more competent than he looks. So he'll do it. Don't worry.
For motion, item number 30.
We'll issue notice here.
Lordship, evening letter is at page 42. Page 42.
Could they tell us, rightly or wrongly, you see, your case is that your predecessor in interest died in harness,
Lordship.
and the date of death is
Prior to the submission of my application,
no, that's
No.
okay. What is the
Yeah.
date of death?
Lordship.
2009,
Yes, 2009.
correct?
And yes,
Just wait.
yes.
Have some patience.
Lordship.
I'll be here till 4:30. Don't worry.
Lordship.
Now,
My
2009,
father expired in 2009.
9 years,
28.
and then you
Thereafter,
applied for.
Made application.
Let me speak.
Yes, Lordship.
Then you applied for appointment on compassionate ground,
Lordship.
but you were given casual employment as Khalasi on 18/8/2012.
Lordship.
Correct.
Lordship.
You accepted that position for 14 years.
No, Lordship.
Appointment as Khalasi, you took that chance.
Lordship.
At the relevant time, you did not object to the non-granting of compassionate appointment to you.
Lordship.
Now, please tell us, under the compassionate appointment scheme,
Lordship.
if I remember it correctly, I may be wrong because I forget very easily. In the state of Nagaland, the compassionate appointment scheme is that for every year,
Lordship.
there is a percentage, 50%, I think,
Lordship.
of the existing vacancies will be given for engagement of on compassionate grounds.
Lordship.
Now, please tell us, if 2009 your father died,
Lordship.
is that vacancy available now? 50% vacancy for appointment on compassionate ground?
Lordship. That 50% as it is a revised notification. Prior to that, only 5% was there. And Lordship.
You are your statement cannot be accepted because of the fact that it is if we are passing orders today, we'll have to take into consideration the present policy. We can't give effect to a policy which has already been superseded.
Lordship. No, I'm just giving some detailed explanation on that. No, Lordship, my humble submission is there. See, I have made an application stating that my father died, was killed accidentally, and then thereafter, I applied my application for appointment. Whereas, as the Lordship has said, he had given me an appointment only on 2012. Now, Lordship, since I'm working under this concerned officer, my superior officer, who is the executive engineer, now and then, since I'm working under him, we have the petitioner has requested, and then
By a representation of 2025,
Lordship,
28/2025.
Lordship. Now, Lordship, after that, my application was forwarded, stating that I should be given on commission regularization, and then that was not considered. Now, here, I'll come to the impunity letter, Lordship. Impunity letter. They have
You
stated,
see, it's the prerogative of the government
Lordship.
or of the officer to write to make a recommendation.
No doubt, Lordship.
But is that recommendation binding on the government?
No, Lordship. But what I'm trying to say is that my father died while in harnessed, and then to the extent of paying to me excursion payment, there is no undisputed fact that my father died in duty. Now, they reply in the impunity letter. They have categorically made mention in 3 points. So he has said that your letter we cannot consider. Why? Because you have applied for suitable post. No doubt in my application, I have not mentioned about the word compassionate, but in the paragraph, I have categorically said that my father killed accidentally. So see, my grievance is that instead of giving me on regular basis, as per the compassionate scheme, I should be given on regular basis. That is the whole grievances. And then they are also admitting, yes, your appointment of the 2012 is done on commissioner ground. So for that grievance, I'm coming to this honorable court, saying that I should be given on regular basis instead of giving me on Kalashi. So I'm aggrieved by the rejection of that impunity letter. Well, so Lordship, at this point, let the
You don't
notice
have a
be-
case. Once you have accepted that position,
No, Lordship, see, I have never asked for any casual or contract.
but you started receiving your remuneration from you are aware, you can't say that I was, even when I was collecting my remuneration,
No,
or
Lordship,
whatever payment you may get, monthly payment or whatever you get, you can't say that I was sleeping also there.
no, Lordship, my humble submission is that, see, the appointment itself is illegal. He have denied me the fundamental right because
Then refund
I
everything.
don't have any right.
You make deposit of the illegal remuneration you have taken. You take the
Lordship,
benefit.
Lordship, see, I'm saying that, see, I don't have any basis to apply for any post. But in lieu of my father dying while in harness, against that only I have applied. Thereby meaning I am entitled
There
for
can't be a
condition.
presumption. Once you don't apply as a on compassionate ground under whatever you write in inside, please tell me. You see, I have some experience as a lawyer and also some experience as a judge. Now, in 80% of the cases, both you and me would read only the last paragraph, what relief has been granted. What is inside, even if you write 100 pages of judgment, I believe you all have read, you all have been quoting Keshavananda Bharti. Have you read the entire judgment? No. Puttuswamy, have you read the entire judgment? No. So we don't have a habit of reading everything. So you'll have to take that presumption for the officer also. You make an application and they treat that application, give you a job. Now you say that read in between the lines and then find out that I was applying for a compassionate appointment. Is it that not too much?
Lordship,
Finding fault with somebody who gave you appointment in 2009, which you have accepted till 2025, first representation is 2025. That comes after the government issues notifications that persons who are in this compassion on these casual workers will get regular salary and they will be getting a skill pay.
No, Lordship.
Only after that you become wise.
No, Lordship, and what I'm trying to say is that petitioner, since he is working under this concerned officer, now and then she requested to consider her case, but because of non-consideration, she applied officially to the written to the letter to him.
Does
And
anything work in the government on oral submission to any authority?
And Lordship, my humble submission is that I have clearly, the petition has clearly stated in the application that my father died while on duty. And then now they are saying that, no, you have applied only on suitable post. So you are, you should be satisfied with casual employment.
That is the interpretation.
Lordship. And then as per the scheme, I should be given on the, as per the commissioner's scheme. That is what my, Lordship, my
Can be.
submission.
Yes, be dismissing your petition. You have seen the earlier order at page requiring the court to consider. They have considered it. Page 41 is the order. And they have now allowed you as gratia of 2 lakh.
Lordship. So Lordship, my humble submission, at this stage, let the notice be issued.
No, unless you don't keep it pending.
Lordship, my humble submission, because my humble submission is that because this is the third time the court petition is coming before the Supreme Court. And then the Lordship, even payment of ex gratia, it was given on the intervention of the Supreme Court.
But that has not been granted. That has not been granted. Ex gratia, we don't find that your application was there at that time. In 2009, your application for ex gratia was not there. At least I could not notice. I forgot your name, S. Temjen.
Yes, Lordship.
Heard Mr. S. Temjen, learned counsel for the petitioner. And learned government advocate appearing for the state respondents. Next para. In brief, the case of the petitioner is that her father, late Lima Toshi, Limatoshi, while working as driver in the establishment of the Directorate of Economics and Statistics.
Lordship, what earlier it was irrigation flow control, but now it is
Okay.
water resources.
Working under the then Directorate of Irrigation,
Lordship.
Government of Nagaland, had died in harness while performing his duty attached to the Deputy Director, Economics and Statistics, Nagaland. And he succumbed to his injury in the succumbed to his injuries. Full stop. It is projected that the mother of the petitioner had availed all the pensionary benefits and ex gratia compensation from the government of Nagaland. Full stop. On 10/9/2009, the petitioner applied for appointment on compassionate ground before the Chief Engineer, Irrigation and Flood Control, Nagaland. Full stop. The petitioner was initially given appointment as a casual khalasi on 18/8/2012. Full stop. The grievance of the petitioner is that she was appointed as a khalasi on casual basis instead of considering her appointment on compassionate ground. Full stop. It is projected that on several occasions, her superior authorities were requested for appointing the petitioner on compassionate ground However, as such requests were not acceded to, on 11/3/2025, the petitioner had, where is that document? 11/3/2025. The petitioner had requested the executive engineer, Water Resource Department for regularization of her service on compassionate ground. Full stop. The said request letter was forwarded by the executive engineer, Water Resources Department to the chief engineer, Water Resources Department, forwarding letter dated 11/3/2025. Full stop. Thereafter, the petitioner again submitted a representation for regularization of a service as on compassionate ground on 28/2025. So as nothing happened, comma, the petitioner had approached this court by filing WPC 14 of 2026. And this court, by order dated 9/2/2026, directed the respondent authorities to consider the representation of the petitioner dated 28/2025 and dispose of the same with a speaking order within a period of 2 months from the date of receipt of the order. Full stop. The Chief Engineer, Water Resources Department, within bracket, respondent number 3, by a communication dated 15/4/2026, which is challenged in this writ petition, comma, responded by stating that as per records, she has been appointed as Khalasi on casual basis by the order dated 18/8/2012 with yearly extension and that as per the seniority and service position, comma, as the petitioner had completed only 14 years of service in the department, comma, her position in the seniority, casual seniority list is 26, and therefore regularizing her service before others would be infringement of their rights. And accordingly, in respect of the current status, in view of her seniority position and the available slots under the prescribed quota, it was not possible to regularize her service at this immediate moment. And petitioner was assured that her case for regularization will be strictly considered in accordance with her seniority and availability of vacancies as per the procedure followed in the department, as per the OM dated 28/8/2024. Stop. Next para. In the meanwhile, by a communication dated 4/3/2025, the Deputy Secretary to the Government of Nagaland, Finance Department, expenditure, inverted commas B, branch, had sanctioned budget for withdrawal of rupees 2 lakh in within bracket in words, rupees 2 lakh only, bracket closed, towards ex gratia payment to the mother of the petitioner on death of the father of the petitioner on 23/8/2009 on government duty, indicating that the withdrawal authority will remain valid between 6th to 3rd March 2025. You have got that money, your mother got that money? Stop. It is submitted at the bar that as per instructions received by him, the mother of the petitioner has got the ex gratia payment. Next paragraph. Accordingly, the learned counsel for the petitioner has prayed for a direction upon the responding authorities for regularization of a service for which he prays for issuance of a notice. Next paragraph. As per the documents appended in this writ petition, the petitioner, by referring to the death of her father while on duty on 6/8/2009, had applied for a suitable job in the Department of Irrigation and Flood Control. Full stop. From the contents of the said application, within bracket Annexure 2, Roman 2, it does not appear that the application was on compassionate ground. However, the petitioner was appointed as a Khalasi on casual basis by order dated 18/8/2012 passed by the Chief Engineer, Irrigation and Flood Control. Full stop.
Worship, just a second, in this annexure 2, if your lordship may kindly see on the left side of the noting, which was given by the authority, they're endorsing to register, indicating that compassionate case. Lordship, if you lordship may kindly consider that.
Okay. Before this line, you add in with the last line. The learned counsel for the petitioner submits that on the body of the said application, competent authority under his signature dated 10/9/2009 directed registration of a compassionate case. Full stop. The petitioner, having accepted the offer, has been working as Khalasi on casual basis since her appointment order dated 18/8/2022. Full stop. The request for regularization of service on compassionate ground was forwarded by the Executive Engineer, Water Resources Department on 11/3/2025. Full stop. In the considered opinion of the court, comma, having accepted the offer of engagement as a policy on casual basis, comma, after a lapse of 13 years, within bracket now 14 years, comma, the application of the petitioner cannot be ordered by the court to be considered as an application on compassionate ground. Full stop. Firstly, because of the fact that earlier the state had a different policy for appointment of compassionate ground, and that with effect from subsequent, which is the present policy? Compassionate appointment, which is the present policy?
It should not exceed 50%, Lordship.
This is page 36. This is the
And Lordship, another addendum is there, Lordship. In that addendum, the consideration will be made on the date of death. Another addendum is there
after this.
after this, Lordship. And then that sentence has been inserted in this 15, in this. I have annexed in the page 38.
Office and currently is under the office memorandum number capital AR-8/8/78 dated 17/9/2015, read with addendum number AR-8/8/78 dated 9/4/2019. Full stop. Next paragraph. Therefore, comma, as the petitioner has accepted her appointment as a trustee on casual basis, since her appointment order dated 18/8/2012, comma, there would be no legal basis for the court to direct the respondent authorities to consider the application under the compassionate scheme in force. Full stop. Moreover, comma, in view of the assurance given to the petitioner by communication dated 15, impugned communication dated 15/4/2026 for considering her case for regularization in accordance with seniority and available vacancies. comma, it would be open to the petitioner to pursue the said remedy as and when she comes into the zone of consideration. Next one, accordingly, comma. For the purpose of converting the application of the petitioner from an application for any suitable post to an application for appointment on compassionate ground. Comma, the court does not find any merit in the petition and therefore the same is dismissed. Next paragraph, however, it is clarified that this dismissal of the writ petition shall not come in the way of the petitioner to pursue for regularization of a service in terms of the poem dated 28/8/2024. Or any scheme subsequent thereto. To start with the aforesaid observations, comma, the repression stands closed.
Worship, my solution is that since the more petition again is approaches for the third time, and then see, as he has already clearly mentioned in the application that explanation of her father time resident, and then even the authority has endorsed that it is to be considered in the completion case, but they have denied and then they have taken only objection. That is my whole criticism.
That we have taken care of. We have noted in the order.
That is why what my humble submission is that the whether you become on the next day, my humble submission, at that time I'll go through the petition and then.
We have already closed it.
Lordship,
You have passed an order and closed it. You
Lordship,
did not.
my humble submission, instead of
That can't happen. Once we have dictated the order in open court and disposed it of, we can't recall that order.
because it is not me who has a.
No, you see,
but it is only the authority.
you see, Mr. Damjan, we did not start the dictation of the order without putting you to notice. We indicated before you, it's not our duty to tell you what order we are going to pass.
Lordship,
But still considering that we have disposed of the matter in the open court, we can't recall that order now.
Lordship,
That would encourage bench hunting.
Lordship,
We can't do that.
It is my humble submission.
No, it's okay. We take consideration, but we can't concede to that.
And then Lordship, another one was, I just on one subject in the submission that see her father died in 2009, whereas the list which I have been using in my petition, all those maintained lists are the later dates. So I'm no longer in the list also. So they should not deny because there is an undisputed fact that my father died while in France. And even after the accident of expression. So that should since he already recognized, and then there's the actual fact. So the petitioner is suffering injustice. That is my humble submission before your lordship. And then you see, in my application also, I have categorically mentioned that.
We can't consider that. No, we have degraded our inability to
Yes.
consider it
And then
for
that.
substitution.
For compassionate. Yes.
No, you see, position of A cannot be substituted by position B. We have made it very clear.
Yes, because you
But-
post doesn't mean that I should be.
If you see you have not stated anywhere in your petition that the observation of the authorities saying that others 25 people are above you, that you have not stated it's a false statement.
I have included the RTI this application information which I wrote for the department.
But where is your statement in the writ petition that the information given,
And then also my preference is that instead of giving me on the regular basis.
that you have rejected, that you can't, that you have.
Yes, and then I have stated in my petition that no one in my family is involved. My mother is already expired, overage. So unless until I'm given that appointment, I'll be.
Compassion you are not getting, you have dismissed that. Now your statement is that with regard to page 42,
Yes.
You say that now your position is your death, position of you on account of death of your father is above others. We don't find any statement in your writ petition to that account.
And then Lordship, you have categorically mentioned that your application in the first application.
You see, please don't repeat that.
Lordship.
Please
And-
don't repeat that. You see, mere repetition of 10 times
Lordship.
will lead to a 10-time dismissal.
Lordship.
Correct. Your now statement, which you are now considering, is you made a statement right now that on account of death of your father, you should be placed higher than 26. Others are the death of your father exceeds or supersedes others.
That is my allegation, and then I have.
Where is your statement in the writ petition?
I include it as a record. I have included.
Please try to understand
Lordship.
how many files are there today in the record. In our board, how many cases are there? Do you expect us to read each and every document, each and every what you call statement, which and confirm it with each and every document, and come so prepared? Charles Dickens wrote a book, Great Expectations. We did not expect that from you. That we'll not only read the text, we'll also read the documents, each and every word of it. Then yesterday we were hearing a matter. The writ petition and the annexure, the writ appeal and the annexure were about 830 pages. Now, please tell us how much time would I need to read that? Don't expect that much from us. And there's another thing. If we come more prepared than you will be the more sufferer. I'll become an autocratic dictator. I'll not even allow you to open your mouth. That's not good for the bar, neither good for the bench. We only read here and there and then come without making up our mind. I was issuing a notice. You referred to the document.
Lordship, it was not a submission.
I understand,
Because
but
I-
that submission led to, once we read the document, then what happened has happened.
Lordship.
We gave you indication that we are issuing notice. You unnecessarily made us read that document. Sorry.
For motion, item number 31.
But Mr. Das,
Yes.
there are 2 or 3 things I may refer to you before you begin.
Yes.
You see, your case is that the tax recovery is being sought for by issuance of a Bakijai notice. Your case is that the person who was in default had already died,
Yes.
but the business was going on. We don't know if there is anything on record disclosing that on death of the concerned person, applications were made for the change of the license and others in other name. Now, once a recovery certificate is issued under the Bengal Public Demand Recovery Act 1919 or 1917, I forgot. There are a few requirements. You have the act with you.
Yes.
No, you have it.
But only, my lord, I'll just, your lordship is right.
No, I'll
Yes.
just give you
Yes.
some provisions. First is 34.
Yes. Bengal Public Demand Recovery Act,
Yes. First is section 34,
34,
and then 51, 53, and 54.
34. Yes. Reference to civil code, 34.
Yes.
Yes.
Then 51,
51,
53, and 54.
51 and 52.
51, 53, and then 54.
Yes. An appeal.
Yes, 53 is revision and then 54.
Right.
So if the authorities are there
Yes.
where you can have alternative remedy.
I was prepared for that.
Yes.
I was prepared for that, but the whole case here arising out of a particular license which has been given to a dealer. Number one, license was given to a dealer with Seba Enterprise. And if your lordship looks into the license which was granted at page 39. This is a trade license which was issued to Messrs. Seba Enterprise. Lordship at page 39.
Yes.
Lordship got it. 39 serial number 3. And the proprietor is number 4, AR. And the category of business your lordship will see, fuel retail outlet for SR Limited.
Yes.
Now this SR Limited now has moved to Naira. Now your lordship will please see at page 41.
No, but we find a missing link here.
Yes.
You are producing a trade license,
Yes.
but you are not producing the registration certificate of the under the taxation department.
No, we don't, my lord, that's what I want to point out before this court. My lord, whether, my lord, I have some judgments are there. This license cannot be transferred. Like a wine shop, my lord, you cannot transfer. Like my lord, arm license cannot be transferred. So this license cannot be transferred. Only a power of attorney has been given to me only to run this business. Now, my lord, there was a demand which was made by the sales tax authority. Now, if your lordship looks into it, the demand which was made.
2016-17 period.
Yes.
2 lakh rupees.
And who paid? Please see at page 43. Who paid? By the payment has to be made under the statute only by the Saba Enterprise Limited. They are the licensee. They have to pay it under the statute. So it is nowhere, my lord, under the statutory requirement that the power of attorney has to pay. My lord, am I clear, my lord? The power of attorney doesn't have to. That's why we said that he has acted without jurisdiction by issuing a notice to us that pay this amount. We are not liable to pay under the statute. Under the statute, my lord, only liable to be paid is this dealer, my lord. Now, if your lordship kindly looks into.
No, but you are operating it. This is stated here.
I'm operating it. I was operating. That doesn't confer under a statute that I have to pay. The payment has to be made by the dealer. Under this, now I show one judgment. I know my lordship will ask that. I was prepared one judgment of the Supreme Court where it said that my lord liquor is given to Mr. Ray. A license has been given. Now there is a partnership deed which was arranged. Now they applied, my lord, before the income tax authority for registration. That was denied. They said no, you cannot apply for registration because under the statute only it will confer to the licensee only. Now I'll show. That is why I am saying, please see the period at page 43, my lord.
You see in 2016-17.
Yes, my lord, all this has been by Seba Enterprise. I know your lordship, that was the first. I also thought in one way that why not the power of attorney holder? Why not? Because he was.
Because you step in as a garnishee
No,
under 46A.
that under the statute, it is not that the power of attorney has to pay for it on behalf of the Seba Enterprise.
That would mean that a dead man is carrying out the business.
2016 died. 2016 died.
So therefore, the
See
business
that,
is being
no,
carried out.
Our whole case is that we were not operating itself. When the son came in 2019, 2018, the son said that yes, let us enter into partnership deed. Now we said that you don't have a locus on it. How it can be? So where is my lord? I am asking myself. Where is that power of attorney is gone, my lord? Once your lordship knows it, 2016, once he dies, in 2016 he expired.
So there will be no meaning to that power of attorney, my lord. So the your lordship will kindly see that was issued by Seva Enterprise.
That is, you see, that you are taking advantage of an illegality committed by you.
No, that's not. Well, I am not operating, my lord. I was not operating. That period to I have made a statement there itself.
No, before the authorities, there is no
See.
statement made.
Page 71, kindly see the notice, my lord.
No,
Kindly see the notice
You-
at
you
page
see-
71.
you see, you have not denied your liability before the authorities. The first requirement is,
No, I have denied. That's, my lord, I have denied.
where is that?
Yes, that is, I don't have to pay, my lord. No, notice has been issued to whom, kindly see 71, my lord. 71, kindly see. Notice has not been issued to us. Please see 71, my lord. Please see 71, notice has been issued to whom?
71.
71. Two 2025. Please see this, my lord.
Yes, on the proprietor.
Proprietor,
The
yes.
death of the proprietor was never known to the
Yes.
authorities.
Now, man, please see, man. Minus so notice to show cause at page 73. '73, '75. Kindly see, my lord. 73, 77, 77, my lord. 79. Once my lord C died, my lord, where is the petitioner I remain? Automatically I cease to operate, my lord. This is C, my lord, at page. This is has been given as 79. How? Proprietor is Shiva Enterprise. Now see, my lord. Now only when my lord see at page 83, my lord. Now see at page 83. Kindly see at page 83, my lord. What you got in 83, my lord? With reference to subject cited, honor to forward case of warrant of arrest against so and so. Message Seva of Message Seva Enterprise. Bracket they said power of attorney holder. My lord, power of attorney holder, once he expired in 2016, there is no question in God, my lord. Where is the question of the power of attorney holder will come into way, my lord? The sun is operating, my lord. Whatever all profits that has been derived by the on the basis of this petrol pump, that particular automatically will go to his son. Now there was the son invited. Son invited said that let us enter into an agreement. Now he said that unless the license is not being transferred in your name, how can I operate? Please see at page 83, my lord. My lord, I know, my lord, that troubling your lordship one judgment if your lordship permits. Yes.
No, because the requirement of law is that you will have to file a application for application before the certificate officer denying liability.
No, that's for.
Once you file that application,
Notice has not. Say the notice not issued.
warrant has been issued against you.
No, so warrant will be issued when the notice was issued to us, my lord. Warrant, please see Bengal Recovery Act, my lord. Section 7, kindly see, my lord. Please see, my lord. Let's take the worst part, my lord. Let us take the worst.
I'll just take a break and come back.
I will make two leg of argument. First leg of argument is that I could not have been issued notice to me, number one. Because it is only a power of attorney under the statute, only licensee has to be. Let us take for the worst scenario, like your lordship said, that yes, what happens? That you are liable also to pay because you are running the pump. Now the warrant of arrest has been issued. There are certain procedures to be followed by you. Now, if your lordship can see para 30, then I will show the provision of the statute. Please see para 13. Let us take for an instance page 17 minus para 30 of my petition.
Okay.
Let us take for an instance that yes, you are also liable to pay. Whether they have followed the procedure before warrant of arrest has been issued. Please see page 17 para 30. Lordship, got it?
Yes.
It is to be stated and submitted. No notice has been issued under the Bengal Public Demand Recovery Act 1934, which no warrant could have been issued by the certificate officer under the said act without issuance of a notice for which the same is in violation of the principle of natural justice and also suffers from statutory procedural lapses. According same is unconscionable, bad in law, arbitrary and liability satisfied. Even your lordship takes into account that yes, whether the procedure has been followed before warrant of arrest was issued. Our specific stand is that no notice was issued. That our specific stand, my lord. Even, my lord, we are not liable to pay. We are not liable to pay any tax. And because statute provides only the liability only licensee has to pay. Now, in this case, I will show one judgment of the Supreme Court. Please look into that. Please see section 7, my lord. Before the judgment your lordship posed,
You read it.
see section 7 your lordship read it.
Yeah.
My lord, then I don't want to trouble this court. Please.
Has to be served on the judgment data.
Yes, right. Now please see, very interesting, 1996, my lord. 1 SCC page 3, my lord. Now, please see the facts that I look into facts, then I will show the, my lord, now, my lord. Para 3 is the facts. Please see para 3. I mean, your lordship permission may I read. A license for retail sale of country spirit under supply system in form CS number 3 of so and so was obtained by Biharilal Jaiswal in respect of 22 outstall shopping so and so Raigar in the public auction held in January 1968. License was effective for a period commencing on 1/4/1968, ending with 31/3/1969. Mr. Jaiswal entered into a partnership with 10 other persons to conduct the business under the said license. Partnership is evidenced by the deed dated 30/8/1968. An application for grant of registration to the said firm under section 184, 185 of the Act was filed in Form 11. Income tax officer rejected the application for registration on the ground partnership had been formed in violation of clause 6 of general license condition prescribed by the Madhya Pradesh excise is illegal and cannot therefore claim registration under the Income Tax Act. On appeal, the Appellate Assistant Commissioner directed the Income Tax Officer to grant registration as paid for. Against this order of revenue appeal to a tribunal. Tribunal reversed the order of the Appellate Assistant Commissioner, restored the order of the Income Tax Officer. Thereupon, SSC applied to tribunal referred to question under so and so which were refused. Application to High Court under section to refer the aforesaid was also rejected as stated up. Against that, my lord, it went to the Supreme Court. Now, my lord, will kindly see the finding of the Supreme Court is in paragraph 19. Please see 19, my lord. In our opinion, the correct position appears to be we are confining ourselves to partnerships entered into with respect to license permit granted under the state excise enactment. This enactment deals with intoxicating liquor, that is to say, production, manufacture, possession, transport, purchase, and sale of intoxicating liquors, entry, age of so and so, other so and so. It has been held by the court repeatedly no person has a fundamental deal or trade intoxicating liquor state is also res extra commercial itself. Please turn to the next page, placetum C, my lord. Placetum C. The object after B, my lord. The object will be defeated if the license is permitted to bring to a stranger into a business, which would mean that instead of license carrying on business, it will be carried on by others. A situation not conducive to effective implementation of the excise law and consequently deleterious to public interest. For this very reason, the transfer of subletting of license is uniformly prohibited by several state excise enactment. It therefore follows any agreement wherein the license is transferred, sublet, or a partnership is entered into with respect to privileged business under the state license, contrary to the provision contained in the relevant excise enactment, is an agreement prohibited by law. The object of such an agreement must be held to be of such a nature that is if permitted, it would defeat the provision of the excise law within the meaning of section 23 of the Contract Act. Such an agreement is declared by section 23 to be unlawful and void. The question is whether such an unlawful or void partnership can be treated as a genuine partnership within the meaning of 185(1) and whether registration can be granted to such a partnership under the provision of the Income Tax Act. And the rules made there, we think not. When the law prohibits the entering into a particular partnership agreement, there can be in law no partnership agreement in nature. The question of such an agreement being genuine cannot therefore arise, where of course the statutory provision, now important, statutory provision, condition of license do not prohibit the entering into a partnership. It is obvious such a partnership cannot be held to be illegal, unlawful or void as held by this 14. But where there is a specific provision, as in this case before us, any partnership entered into would be unlawful and void agreement within the meaning of section 23 and no other law, whether state or central, can recognize such an agreement. The fact that such a partnership can be permitted by the collectors does not detract from the mandatory character of the clause. As pointed out above, license condition expressly prohibits therefore breach of any condition of license or act or rules made thereunder license may be cancelled. The context should not be forgotten. The grant of registration, it must be remembered, conferred a substantial benefit and its member. There is no reason why such a benefit should be extended to persons who have entered into a partnership agreement prohibited by law. One arm of law cannot be utilized to defeat the other arm law. Doing so would be opposed to public policy and bring the law into ridicule. Well, what I want to say in this case, man, when a license was granted to the dealer who is the owner of the pump. That particular right cannot be conferred to me, where under this statute, the requirement to pay sale tax will only go to the dealer of the petrol pump. That's why the dealer of the petrol pump was paid. Now let us take second instance, man, where your lordship is saying now. Even the worst case, man. Let us take the worst case, my lord. Even, my lord, what the warrant of arrest before issuing a warrant of arrest, worst case, my lord, a notice has to be served, my lord.
But then why did you give page 97?
Which one, my lord?
97.
97. Oh, that I have denied. This is not my signature. I am filing that's a statement as you say. We are taking action against this. That is not my signature. Somebody has done it on my behalf. Neither this purported reply also. I have made a statement and I am going to lodge an FIR against that, my lord. That is not my signature. Who has done my statement? I have made a statement. Please see para 10, my lord. Specific I have denied.
Then who has issued this page 91?
I'm sorry, my lord.
91?
It's 91. That also I have denied. My reply I have denied. This is not my signature. Who has done, I don't know, my lord. And I please see para 10 of my statement which I have made, my lord. Please see, my lord. Served in the petrol, someone informed the petitioner. Upon gaining knowledge of warrant of arrest, the petitioner upon Enquiry came to know about the aforesaid notice, reply, dated named to the so-called notice and purportedly find the name of petitioner and a reply issued by the authorities. It is to be stated a petitioner has not made any such repetition or reply, as no so-called has been served, and there is no question of petitioner submitting any reply. The petitioner denies making such reply, and for such forgery he is also going to take necessary legal steps. Against the same reply, the Deputy Commissioner in his capacity as certificate of issued a reply and have also enclosed undertaking purportedly being signed by the petitioner for payment of demand. It is to be said petitioner not made any undertaking and is going to take legal step for such forgery. I think.
But then how would you have a copy of all these letters?
Which one, man?
Page 91 onwards, how would
I
you
made
get
a
a?
statement, man. Please see. Para 10, I have made a statement. I made a statement.
But how did you get the copies of page 91 and all copies if you are not the author?
No, and this is what I came to know from the petrol pump. Someone from Perry informed the petitioner gaining the knowledge of warrant of arrest. The petitioner, upon I came to know, replied. Then I came to know, and from the petrol pump it is given to me, my lord. Then I was shocked. Then I came to this court, my lord. Please see, my lord. Please see 81. And let us see the reply. 19/3/2026. That the SOPAS at page 91 and page 81 is given to how? Kindly see, my lord. And the reply, SOPAS reply in reference of 19/3/2026, which is at page 81. Don't you got it, my lord?
No, that is why we were thinking that you are already in what you call in control of the business.
I'm sorry, madam.
That is why we were thinking that you are in full control of the business.
I know, that's why I'm saying, madam, how can I be in full control of if this SOPAS reply is only in respect of how? The SOPAS is issued to the how, the owner. If you want to kindly see at page 43, the period which they have mentioned about the tax to be paid, that has been paid by Siba Enterprise now at page 43. 43, my lord. Same minor authority was asking tax. 2016. If you see on page 46, that is 2017-18.
You are appearing for the tax department?
Respondent wants to sell.
We'll just give this to you.
We have a copy.
Huh?
We have a copy.
It's okay. Section 9.
Worship, if the petitioner has no relation at all with that assignment, there's a forward attorney, executor. Then how, on what circumstances petitioner oppose to use a monopole? That's the.
No, because he's projecting, Mr. Das is now projecting that somebody in his name has given that show cause reply. We were thinking that it was issued by him. Now, he's taking two grounds. Number one, that the notice to a defaulter was never served on him.
Yes.
This is one. And second ground is taking that the representation made was not by him. And he says that he's disconnected with the business in 2016. So what we are proposing is,
Then there is an ample opportunities given to
no, that's not the way. That's why we are showing you that 9, section 9.
Yes, but section 7 also, if you have a right, maybe you deny the liability, then oppose the authority under section 7, like you have denied the liability. That's another.
Denying liability is 9, section 9.
And again, Lordship, when you create the independent Louis, then how the article 266 will come? Because they have the
Because
ample opportunity to.
we'll ask them to file, we'll ask the petitioner to take recourse to section 9. Please see, Mr. Das. Section 9.
There should be another question. So long as the stand of the petitioner's submission is such, notice will never come to him. The word here, attorney, how wrong? It will come to the executive.
No, perhaps that's not right. If he is not the recipient of a notice of defaulter.
Of course, he is an attorney holder.
No, it's all okay. But you see, can an attorney be saddled with a civil liability?
No. But
No.
in that case, you see, as per the petitioner has clearly stated that license is not transferable, it is not out at all. But license is, since it is not the case, but I'm going to the submission of the license is issued in the name of the executive of the power of attorney.
It will always be in the name of the proprietor. License will always be in the name of the proprietor. He says that the proprietor has died in 2016. After 16,
Yeah, Your Worship, I understand, whatever may be, he is here, he are countering against the provision provided under Bengal Public Demand Recovery 2013. So there is an ample opportunity for the petitioner to oppose under the provision of law. Instead of coming to the.
that's why we will send the petitioner to the authority for filing an application under section 9. If there is any delay, that delay will not be a factor to be considered against the petitioner, and the authorities will take up the matter and decide the petition denying liability. We refer it back to the authorities to consider this, to allow the petitioner to file a which one? No, once this is there, we'll take it that there's a notice. Now, warrant of arrest has been issued. It will be deemed that you have a notice of the liability to pay. And then on the basis of that, you will proceed, file an application of denying liability. Until then, till the decision is given, that warrant of arrest will not be given effect to.
So, okay, your lordship is saying that once a notice has maybe has given to the owner of the pump, you are aware of it. When a notice, that's what your lordship is saying.
Yes, because of the fact that you will also have to
Because
satisfy the authorities
Yes, correct.
that those applications were not made by you.
Easier, subject to your lordship, I'll agree to it. It would have been easier if a notice would have given to me, spelled out everything.
No, once a warrant of arrest is made,
Yes,
it can't proceed, it can't follow the notice again.
that warrant of arrest, what we are saying, that your lordship has asked me, that warrant of arrest was not proper in accordance with the procedure that has been laid down.
That's why we are giving you an
That's what your
opportunity.
lordship is right.
We are giving you an
Your lordship is
opportunity.
absolutely correct. Your lordship is right. That once a notice is given to me, of course, my lord, then your lordship is saying that you can reply and denying all those
So
things.
this warrant of arrest, which you are now in your cognizance,
Yes.
will be treated as a notice to you, and then you proceed
Yes.
against him. And that
Notice to warrant of this,
Ah.
in this issue. And it came to raise a forgery and so many things. So there is completing authority under the version of law, not before this one.
correct.
If it is a forgery or whatever it be, it is not an appropriate form. It is a appropriate form committed authority under the provision of law. So it should not become under the Article 2.
And against those orders, you have remedy under 51, 53, and 54.
Only my case before this court that there is an alternative remedy.
No, we are not sending you to an alternative remedy.
Yes.
But we are asking you to comply with the statutory requirement of Section 9 of denying your liability. That representation ought to have been under 9, but still we give an opportunity to you, to the petitioner, so that he can file an application within 10 days from today. An application denying liability.
I have the response
Yes,
to the purpose of page 81.
yes.
As if
It's a original notice to you.
As if I am a licensee holder.
No, it's a notice to you. You may not be, may not be a licensee, but it's anybody against whom liability is.
Lordship has to spell out. Your lordship has to spell out that this
You
notice
tried
is
that.
not to the power of attorney holder, it is to the owner of the petrol pump. Because
Make it clear.
81 is the-
No, we are not saying anything.
Yes.
You are denying that liability. The High Court will not endorse whether you are the owner, or you are the proprietor, or you are the manager. We are just saying that this will be deemed to be a notice to you, and therefore, whatever status you think is deemed appropriate, you deny your liability by virtue of Section 9. You can just sit down and consult so that.
What I'm saying, my lord, the lordship is my argument is that this notice apparently at page 81 is to the licensee of the petrol pump. And the warrant, my argument is the warrant of arrest could not have been issued by them.
So they will take care of it.
Warrant of arrest.
If there is no, in your defense, you can take that. If there is no notice, then warrant naturally will not follow.
Warrant of arrest could not have been issued.
Correct.
Because this pump, the SOPAs have been issued to the owner of the pump.
That's why that's why we are giving an opportunity of denying liability.
Yeah, with great respect. What they could have, this warrant of arrest will go and they have to issue a fresh notice.
No, we are not doing that. We'll just keep in abeyance till the matter is decided. That will be kept in abeyance. It will not be acted upon. And if there is any order passed in the order denying liability, you have your remedies available. Because the additional advocate general is right, whether the signature is yours or not, would not be open for a decision in this writ petition. It will be highly disputed questions of fact.
That's what I'm.
So we.
The section 29 of the.
The problem will come to what is power of attorney.
No, you can deny that liability.
Manager and your lordship knows that the power of attorney is only on behalf of the principal he acts. Ultimately,
You take your defense, whatever is available.
is the fruit is not enjoyed by the agent. It is only by the principal it enjoys the fruit.
Correct.
It enjoys the fruit by the principal. So nothing goes to the agent. He only acts on behalf of the principal.
So that is the difference we take.
Any realization is to be made. Now, suppose my lord, for a moment, let us say that we accept it, yes, we run the petrol pump, we didn't pay it. Let us for that. Let's take that argument. Now, the liability of the tax is the owner. Now, suppose the power of attorney holder doesn't pay. Now, tomorrow, the licensing can file a suit against it. This is what we have in internal arrangement. Power of attorney was given to you, but in spite of that, you have not paid the amount. That's one way of looking into it.
No, Mr. Das, you see, we have a different way of thinking. You see, if that is the case, then the only thing we can now do is to issue a notice whether this. No, we understand, but then what happens is that whether the department has issued a notice to you or not, we'll have to give the additional advocate general a notice. He'll have to bring instructions, and in the meantime, the warrant is there. It is operating against you. But if you dispose of the matter, allowing you to file an application for the statement denying liability, that warrant of arrest is postponed for you. And naturally, if you have anything to say, you can always have that statutory remedies available. We are sending it only because you are denying the liability.
Only my demands file came before this court. I will take an action against whose my signature has been report. That's number
But
one.
we can't.
That's
You
a
see,
different aspect of the matter.
no, you see that. Let us assume that to be have already been initiated.
Yes.
That decision will come when
But
the
that
courts
is-
will decide.
That is different aspect.
Yes.
Where we will take appropriate remedy before the appropriate court. Who has told your lordship is not the area to be decided that part. Only the area to be decided by this honorable court, whether being a power of attorney holder, let's put it this way, my subject to what your lordship said. Being a power of attorney holder, whether I am liable to pay the tax or not. Being a power of
That
attorney
depends
holder.
on how the document is interpreted. For that, will also require
Yes.
the representatives of the deceased to be joined in as a party, and we expand the scope of 226 to decide a inter-party dispute. Now, who will decide whether under the liability was there under your power attorney or not? We have to hear the other side, legal representatives.
Done, my subject to your lordship's
So
action.
long as the petitioner generally liability, comfortably he can invoke the section.
Can it be done this way, subject to your lordship approval and acceptance? That if your notice is issued in this case, and whether any notice has been issued prior to the warrant of arrest to the power of attorney holder one. If
You
that
give a
is-
notice
and
then.
in the meantime, the warrant of arrest should not be given effect.
No, but then unless we know, it can't be stayed. That's the problem.
Now, apparently, warrant of arrest has been issued, that's why I am before this honorable court, my lord.
You wait for 3 days, we'll ask him to produce next Thursday, he will produce it. The instructions.
Then my lord, your lordship will.
Because we are not averse to that. If that's the inquiry you want to make, we'll request the additional revision by day after tomorrow, we'll bring it. Tomorrow is the division bench day. So you'll get it day after tomorrow.
Or my lord, I respond, my lord, to the notice.
That would be more better. Mr. Das,
Yes.
we don't want you to give an answer right now. You can go and consult and then come back at 2 o'clock. We'll take it up.
Oh, it's okay, man. It's okay, your lordship will pass that order, response. Only that they will provide the license. We don't know what is that license also. We know the license is a name of the owner. We have not seen the license because the power of attorney was entered.
No, that has been admitted by the respondents.
No, that's true, my lord. I know, my lord. That's
No,
the-
they have given it in writing.
Yes,
Your authorities the authorities in their response
yes,
has given it in writing, page 95.
yes.
Page 95, they say that matters highlighted in proportion of his son's name so and so did not happen and the POA become invalid. Page 95,
Yes,
para 2.
yes.
We have read this. That's why. So they are not insisting that this power of attorney is valid.
Yes.
But they say, you see, this is paragraph 3, and this also had, took into consideration. That is why we started asking a question like that. Para 3,
Yes.
they have taken that response to be yours, and therefore you are in control of the management. We also had the same feeling without hearing you.
Control of the management doesn't mean that I am liable to pay tax under the law. Control of management with great respect. If I have got a power of attorney to look after the particular, there's their reply, my lord. Of course, their reply is there.
That where is that power of attorney?
Please see the power of attorney.
Which page?
Page and page 40.
Page 41.
Yes. To sign, execute, perfect, complete document, controlling product, document required to negotiate, enter, correspond with company, and all everything as a suitable document connection to sign, seal, execute, perfect, complete document with company department connection said to do all acts, these are necessary for an execution of proper performance at petrol pump. Yes, sir. I do agree to allow, verify, confirm all and what to so and so, so and so, so and so. There is nothing where it mentioned all essential liabilities has to be paid by the foreign on behalf. My lord, what I am saying, the essential liabilities, not a single whisper has mentioned the power of attorney. The only essential liability has to be paid by the power of attorney holder.
Okay. Mr. D. Das, Learned Senior Counsel, assisted by Mr. R. Sharma, Learned Counsel for the petitioner. R. Sharma and Mr. I. Das, Learned Counsel for the petitioner. Also heard Sri Additional Advocate General for the state, along with Mr. Just give the name and writing, we'll make mistakes. Along with also, on behalf of the state respondent numbers 1 to 7. Next, in view of the nature of order proposed to be passed, the service of notice on respondent numbers 7 and 9, sorry, 8 and 9 is dispensed with. Next para. In brief, the case of the petitioner is that he is the power of attorney holder of Mr. Akangmeren, Akangmeren. Next word is AO, who is the owner of Messrs. Seva, SHEBAH Enterprise. Holding dealership license. No, full stop. The said Messrs. Sheba Enterprises is the petroleum product dealer of SR Oil Limited and running a petrol pump, a retail outlet at which place? No, that is your principal's address. Where is the petrol pump? We don't know. Ajay, just leave it. Petrol retail outlet. It's okay. We just say retail outlet. It's okay. We are saying just retail outlet. Location we are not saying. Retail outlet.
That's 75
Huh.
is so and so. It's number 70.
It's okay. We are saying just retail outlet. Retail outlet. Full stop. The petitioner projects. Where is the date of death of the owner? Where is the date of death of the owner?
2016, not 2016.
Stop. It is projected by the learned senior. It is submitted by the learned senior counsel for the petitioner that in the year 2016,
Yes.
the principal, i.e., Akan Meren Ao, had passed away. Full stop. Referring to the contents of the said power of attorney dated 8/8/2007, it is submitted that as per the said power of attorney, no liability whatsoever accrued upon the petitioner. Full stop. It is further submitted that the legal representatives of the deceased principal did not reconstitute the dealership. So accordingly, it is submitted that on death of the principal, the said power of attorney has lost its force. So it is also submitted that on the strength of the said irrevocable power of attorney executed on 9/8/2007, the liability to pay any tax, the incidence to pay any tax was not on the petitioner. Full stop. It is further projected that in the meantime, the competent authority, i.e., the Assistant Commissioner of State Taxes, Ward F, is not the party here. Assistant Commissioner of State Taxes. You showed us page 71. He's not a party here. Okay. The person, state taxes had issued a notice to the deceased principal under section 10 within bracket 1. Under no, comma, requiring submission of return under the Nagaland within bracket sales of petroleum, comma, etc. Full stop, bracket closed. Taxation Act, comma, 1967. Full stop. It is submitted that no notice whatsoever was addressed to the petitioner requiring him to pay to either file a return or to pay taxes or arrears, area taxes. Full stop. This was followed by a notice under Form 30 dated 13/10/2025 requiring the deceased principal to show cause as to why warrant of arrest should not be issued. Full stop. Such notices were issued on 13/10/2025, 6/2/2026, 3/3/2026, 19/3/2026. Full stop. Thereafter, the certificate officer, comma, Office of the Deputy Commissioner of State Taxes, comma, Dimapur Zone, within bracket Respondent number 4 forwarded a warrant of arrest in respect of the petitioner to the Commissioner of Police, comma, Dimapur, on 7/4/2026. And request was also made to the police authorities for providing assistance in execution of the arrest warrant. But Mr. Das, even in this letter, we forgot to tell you this request at page 85.
Yes.
There also you see second paragraph. He says that you appeared at the hearing. Very categorical statement. The power attorney, Devanand Prasad, appeared on 1 or 2 occasions and assured us. Full stop. Next, the learned senior counsel for the petitioner has submitted that the petitioner has come to know that pursuant to the show cause notice dated 19/3/2026, comma, it has been projected as if the petitioner had appeared before the Deputy Commissioner of State Taxes, comma, Dimapur Zone, within bracket respondent number 3, praying for calling back of the certificate proceedings by a presentation dated 15/4/2026, which was rejected by the Respondent number 3 by a communication dated 20/4/2026. Stop. Accordingly, it is submitted that the petitioner, having denied making those representations, will be taking appropriate steps in accordance with law. Stop. Next paragraph, it is submitted that the writ petition has been filed as because a warrant of arrest has been issued against the petitioner without service of any prior notice to the petitioner demanding taxes. Stop. Just give that book. Stop. Accordingly, it is submitted that the warrant of arrest has been issued without a preceding show cause notice. So accordingly, prayer is made for setting aside and quashing of the warrant of arrest. And for not giving effect to the said warrant of arrest with further direction to the state respondents not to recover any sale tax from the petitioner, as well as for setting aside the certificate proceedings. You are referring to which provision for that warrant of arrest and setting that notice? Which provision you are referring to?
Bengal 6 and 7.
Huh? 7.
7 of the Bengal code, 7.
Full stop.
6. It is start
In-
from 4, 6, 7.
In
4,
support
5,
of his
7.
in support of his submissions, the Learned Senior Counsel for the petitioner has referred to section 4 to 7 of the Bengal Public Demands Recovery Act, 1913, and he has also placed reliance on the case of Biharilal, Biharilal, Jaiswal, Jaiswal, and others versus Commissioner of Income Tax and others, within bracket 1996, bracket close 1 SCC 443. Next paragraph. Per contract, the learned additional advocate general, opposing the prayer made in the writ petition, has submitted that the petitioner had appeared before the Deputy Commissioner of State Taxes and submitted a show cause reply. And therefore, he submits that the petitioner was managing the affairs of the business of Messrs. Sheba, SHEBAH, Sheba Enterprises. And therefore, he justifies the state action against the present petitioner. And opposes any interference to the warrant of arrest for recovery of the dues recoverable by the certificate officer. Next paragraph. In view of the peculiar facts and circumstances of the case, where the petitioner is denying submitting any show cause reply, and also denies the service of any show cause notice to the petitioner, and taking into consideration that the petitioner also possesses as per the power of attorney holder, even if his managing of the business is accepted, still no financial liability would could be saddled on the petitioner merely because of the power of attorney in view of the death of the principal way back in the year 2016, which, according to the learned senior counsel for the petitioner, invalidates the power of attorney. First of, accordingly, taking note of the above, the what is of the considered opinion that as regards the demand made in respect of the proprietor of Messrs. Sheba Enterprises, SHEBAH Sheba Enterprises, stated to be deceased, and so justice would be made to allow the petitioner to file an appropriate application before the certificate officer under Section 9 of the Bengal Public Demands Recovery Act, 2013, denying his liability on any of the grounds on which this writ petition has been what are the grounds that has been pleaded in this writ petition. Accordingly, it is provided as follows. Number one, that within 10 days from the date of the order, the petitioner would file an application under Section 9 of the Bengal Public Demands Recovery Act, 1913, before the certificate officer in whose office the certificate was issued, or would be executing the said certificate, and take any such grounds as he may so deem fit and appropriate, including those taken in this writ petition. Next para. The certificate officer will be adjudicating the application for setting aside application denying liability, as a petition denying liability, would not dismiss the application merely because there has been some delay in the presentation of the application, and the same shall be decided on merit instead. Next para. It is needless to say that in the event the petitioner is aggrieved by any order that may be passed, it would be open to the petitioner to avail such statutory remedy as may be available to the petitioner in accordance with law. Next para. In order to facilitate, this will be all subparagraphs, ABC 1, 2, 3, whatever, and then main paragraph. in order to facilitate the appearance of the petitioner before the certificate officer, the operation of the warrant of arrest, which page was that? Eighty-three. No, this is only a forwarding. Oh, okay. Any warrant of arrest which has been issued and or pending execution against the petitioner, namely Dinanath Prasad Shah, that may have been that has been issued by the certificate officer, Office of the Deputy Commissioner of State Taxes, within bracket respondent number 3. No, 4. 4. Shall not be acted upon for a period of 10 days from the date of final order that may be passed by the certificate officer, within bracket respondent number 4. Next paragraph. Accordingly, the Commissioner of Police, Dimapur, Nagaland, within bracket respondent number 5, to whom the warrant of arrest was forwarded, shall inform the concerned authorities to whom the warrant has been forwarded for execution of this order. Next paragraph. Accordingly, the petitioner shall produce a certified copy of this order before the certificate officer, within bracket respondent number 4, and to the Commissioner of Police, Dimapur, within bracket respondent number 5, to bring the order to the notice of the said authorities. Next paragraph. It is clarified that this court has not examined or adjudicated any issue which has been raised in this writ petition. So accordingly, the certificate officer shall decide the matter without being influenced by any observation made in this order.
How much time to file implementation?
10 days from today.
10 days and thereafter 10 days. Thereafter.
Final order, so that if there's any adverse orders, that will not be affected.
Yes.
We are giving protection till then.
Till the order will pass.
10 days after the order. 10 days
No,
before.
that's fine. That's fine.
But Mr. Das or Mr. Sharma, please give a copy of the order to also to the Additional Advocate General for his record.
Yes, sir.
Once you get the order, please give it to him.
Yes.
Because he must also know about it.
Will provide.
He'll come. That's why we have already called.
For hearing, item number 34.
Yes, my lord, I'm here.
Yes.
Not for your lordship convenience, we have prepared a note which my client will tender to your lordship.
Yes.
Would your lordship consider this, lord? There's a note which is tendered. It's called an argument note. I've also this morning, lord, moved an application, and I'll just point that out. This note.
Yes.
But to avoid any controversy, so to speak. We've said that we have no objection to Assam Rifles being a party, and also Major Goel. So kindly just see my application today is 76 of 2026. Fine. Kindly just see this.
Yes.
And along with that, Lord, I have stated that at page number 2, that Military Secretary Branch, Headquarters Directorate, Rifles Latkor, and Madam Pooja Goel be added as a proposed respondent number 2 and 3. So that is one part. I am, of course, objecting to the contents of the application by Assam Rifles because my case is para 4 that without prejudice to my rights, to what they, because they've made material separations and without prejudice to my rights, they may be made as parties. That's part 1. I don't think the other side can have an objection to that. And since the officer, respondent number 3, is present, though representing the part in representing the government, Assam Rifles, I don't think there can be any issue in delay.
Yes.
Yes, Lord. Now, Lord, may I just come to the main matter, since the main matter is to be argued today. And nothing will survive also in the impleadment except my objection may be kept on record because I've conceded in essence, I've agreed to the impleadment of Assam Rifles. I don't know whether, yes. Now, Lord, if I may just point out 2 small things. Your Lordship has a copy of my note. Major Love, just pass over a copy of the note.
Yes, we have it.
Now, Lord, kindly note. I had challenged 2 orders, 18th March, as I told your Lordship yesterday, and 1st of April, both in effect transfer me out of Assam Rifles prematurely. It's a 2-year tenure, and send me to the headquarters 86 Infantry Brigade, Western Command. Now, Western Command is where all the trouble arose. That is the reason for my third prayer to say that even if I have to be sent, I should not be sent because it's a punitive transfer, and to send me to Western Command is really to create. I will be doubly prejudiced. So that's the first aspect. Now, Lord, kindly come to argument note point number Roman 1. I'm a JAG officer. I put my service profile. I've also pointed out my duties.
You are having objection to be sent to Western Command.
Yes, Lord, that is my prayer. See that for a moment. Please see that, Lord. And kindly just note, prayer C at page 46, to direct the respondent to not change the place of posting chain of command till the pendency of jurisdictional issues in OA number so and so pending before AFT are finally decided, and can proceed only after leave permission of tribunal alternatively to direct the respondent to post petitioner anywhere in India in a functional jurisdiction area of HQ Western Command and HQ Command where petitioner is already served. That is my only request. So that is where my troubles have arisen. You're really sending me to the frying pan. So I am put back to multiple, I have a genuine apprehension of harassment there. And I've already served there. And that, if your lordship will see, my service record at page number 20, at C1 at 29, not just C2 the writ petition. I'm sorry, my reply to the IEA, my mistake. My reply to the IEA, 74 of 26. See, please see annexure C1 at page number 29. Now, my lord will see here. It says, if my lord just comes to the interim lord at page number, just show that. At second page lord, it'll show July 22 to August 24. Headquarters Delhi area, head consul Western Command, third JAG posting. And below that, September 2024 is my current posting, except between 19th April to 29th October, I was on temporary duty. So my last posting before coming to Assam Rifles was as officer in charge, cell AFT Delhi, and I was at headquarters Delhi area, headquarters Western Command. That's the first part. Now, Lord, please also keep in mind the act, the act, the Armed Forces Tribunal Act. And kindly see, Lord, for a moment. Your Lordship has the act.
Which one?
Armed Forces Tribunal Act, my Lord.
Yes.
Lord, if your Lordship is kind enough to see section 3(0) for a moment. It says, just give me. It says, Lord, 3(0), service matters in relation to persons subject to the Army Act 1950, Navy Act 1957, Air Force Act mean all matters relating to the conditions of service and shall include. Please come to after Roman 4, any other matters whatsoever, but shall not include following. Now, please look at Roman 2. Transfers and postings, including change of place or unit, whether individually or part of a unit, formation, or ship in relation to persons subject to the Army Act. Now, these are not included. I've come against a transfer. AFT has no jurisdiction. Therefore, I came. This read with 14 will make it clear. And kindly just look at 14 for a moment. Save as otherwise. Lordship got 14?
Yes.
Save as otherwise expressly provided in this act, tribunal shall exercise on and from the appointed day all the jurisdiction, power, and authority before that day by all courts except the Supreme Court of India or a High Court exercising jurisdiction under 226 in relation to all service matters. So service matters is defined. 14 makes it clear that only service matters can be dealt with, and that is the reason we are before your Lordship's court. Now, Lord, let me just come back. Let me just come back to what I was saying. My point is, Roman 1, I'm a JAG officer, as I said. My duties are defined. I was deputed. And now please see the policy at page 69 of the writ petition. Does your Lordship have it? 19 November 2009. And please come to 71, which my learned friend on the opposite side for Assam Rifles had read yesterday. Tenure. To obviate any problem in forward peace profile of the officers, it is requested that tenures officers will be in consonance with tenures in other staff regiment ERE appointments. Tenures will be as under B. All staff appointments 2 years. So today you want to send me back prematurely. That in itself is a punitive action. And the law on this is clear. Kindly also see rule number 16 at page number, same page, In the past, some officers were not relieved by headquarters even after the relief had reported. In certain cases, officers from Assam were posted out without awaiting relief, but these officers were not relieved by headquarters. To avoid such problems, the following guidelines will be followed. Any officer whose relief is reported to headquarters will be relieved within 4 days. In case of any difficulty, the concerned section of MS branch will be consulted. Officers will normally be posted out from Assam Rifles on relief, except in exceptional cases may be posted in career interest without awaiting relief. In such cases, it will be ensured that relief are posted within 60 days. So, my lord, on the first they issue a letter for her, on the 15th they say they want to retain me. And now they're pushing me out, and therefore it is completely contrary to their own policy. Now, my submission, respectful submission is this, man. If the posting planning self-analysis note of 24th April 2007, there has to be a consultative process. It can't be an arbitrary unilateral process. And they have sent me as additional officer at headquarters 86 Infantry Brigade with no duties. Kindly just come to page C2 at page 31 for a moment of my reply to the IS 74 C2 at page 31. Take the relevant portion. See para number 2. MS branch has instituted the facility of PPSA through the MS web for carrying out self-analysis by officers while forwarding requests to their next posting. The branch constantly endeavors to enhance the satisfaction by making the entire process more interactive by taking due cognizance to the PPSA forwarded by the officers. No consultation, no, not asked for. That's point number 2. Thirdly, my lord, R1 says I would be allocated duties as per the requirements of the internal administration. Now, the point is you're sending me to Western Media, Western Command, I'm sorry, and you are asking me to do that. I also want your lordship to see, Lord, the kind of material that is put up which causes me some concerns. And my order, my transfer order is with private individuals, Lord. On the 2nd of April, they sent it to private individuals. I ask myself, how can they do this? Please just see that. Please come to page number 51 of the writ petition.
Just a moment, coming back to page 31, this consultation
Yes,
process, you said, who is to be consulted?
But it says the officer also. First clause, just see that again. My lord will see in the first para, second para, I'm sorry. See the second sentence, the branch constantly endeavors. Let's read the whole, in fact. Planning self-analysis, PPSA, through the MS web for carrying out self-analysis by officers while forwarding requests for the next posting. The branch constantly endeavors to enhance the satisfaction level by making the entire posting process more interactive by taking due cognizance to the PPSA forwarded by the officers. Please put it to them. They've no PPSA process done. I'm not keep one thing in mind, and I leave it with your lordships. Your lordships court, Assam High Court has time and again laid down that this, if you don't file a response to a writ petition, it is deemed to be admitted. There's a rule of non-triverse will apply. In fact, Lord, I was fortunate enough to come across your lordship's own judgment, Lord, in 2020, SEC Online, Gauhati 4261. Please pass it over. Now, Lord, kindly see. Para 2. By this writ petition filed under 226 of the Constitution, petitioner is claiming whatever due. So it's a 226 writ. Now please come to para 5. It is also seen that notice of motion was issued on this writ petition by order dated 12th October 2018, Since then, the respondents have not filed any affidavit in opposition despite time granted. Therefore, the court is inclined to invoke the doctrine of non-traverse and to deem that the statements made in the writ petition are admitted by the respondents, notwithstanding the fact that as per the documents appended to the writ petition, it appears that the balance work was awarded to another contractor, which would otherwise mean that the respondents have invoked risks and costs, be that as may. As there is no opposition by invoking doctrine of non-traverse, the writ petition stands allowed. Now, the point is not, Assam Rifles may have come in yesterday, but the union has been here. Respondent number 1 has been there. They chose not to file any response despite notice being issued on 24th of April 2026. And that day, counsel for the CGSC, who is common to both Assam Rifles as also the first respondent, was present in court, accepted notice, but no replies fine. In fact, Your Lordship recorded in para number 8 in the 4th line of the order, on the next returnable date, CGSC shall produce, and if the affidavit cannot be filed, receive instruction and effort will be made to dispose of. Now, Your Lordship said let them file an affidavit if they don't produce the records. Now, I don't know what they've done with the record, because when Assam Rifle comes here, they suppress material information from Your Lordships. So I take this point to say that it's a case of non-traverse, and therefore the abruptness with which this has happened is something disturbing. I come back to, excuse me, the availability of the transfer order, which is at page number 51 of the writ petition. My lord may see that. अपडेट ऑन दामाजी का स्वागत करने के लिए टिबरी सैन्य स्टेशन आतुर है। आइए दामाजी, आपकी बड़ी बेसब्री से इंतजार है। उम्मीद है कि आपका आगमन आपको आपके कारनामों को उजागर करने में मददगार होगा। No, just a minute. Show the other one also. Next page, Lord. Update on Damaji. The Tibri station, this another post, is eager to welcome Damaji. Come on, Damaji. We are waiting with you with great impatience. This is Colonel Mukul. We hope that will be highlighted. And then please come to reply affidavit, page number 40. My photo is placed here. And Damaji, because somebody asked in the earlier post, who's Damaji? My photo was placed at page 40 of the reply. Sorry, at page 41, it says, Damaji is missing. Dear Damaji, please come back. Diwali is over. Now be prepared now for all the whatever of massage, whatever. Justice can be delayed, but not denied. So this is the kind of post by private people being put up, and why my transfer order was sent out. That is an answer which the TGSC and the union respond number 1 or 2 give and respond number 2. But it is their prerogative. They don't want to respond. I'm not going to complain about it. There are judgments of the Supreme Court. I'm not going to trouble your lordship with that. Now, Lord, the second point. We have contrary stands by the Assam Rifles and MS branch, R1. The Directorate of DG Assam Rifles, let's see their IA 72 again. They claim they addressed, they have addressed multiple communications to MS branch to transfer me out as I was facing a court of inquiry and was not able to work. Please see the relevant page 11 of IA number 72. I placed this yesterday as well. My friend has also relied on it. This is their known stand. Their case being that based on this, I was transferred out. Lordship's got page number 11 of their application, IA for impleadment. I'm going to just read one and then point out the others. It is intimated that Kumar, presently posted as ALO. So from 5th August, officer is sending court of inquiry from April till date, and earlier from are pending as legal vetting is mandatory before processing. 3 under Secretariat Headquarters, 17 of HQ, IGAR North is greatly impeding the smooth functioning, is also causing inordinate delays to all matters of discipline, HR violation, legal vetting of court of inquiry, SCRC, GRC pleadings. Hence, it is requested that SS so-and-so major suitable reliever against the officer we posted the earliest, please. Who is this signed by? Amit Shah, Lieutenant Colonel AMS for DGSM rifles. Now, please come to the next letter will be similar. Now, Lord, here, cleverly in para 1, they will only refer to my AFT case, not the court of inquiry. Then, Lord, the reason is court of inquiry is now stayed. Thereafter, Lord, please note the next letter, which is letter dated 10th February. Second para, considering the miscellaneous application filed by Major Love Kumar, it is envisaged that the legal proceedings against the officer are expected to take a long time. It is requested that he may be repatriated to the Indian Army. And there's reference to a miscellaneous application in the earlier para. Copy is attached. Then, Lord, next page, communication of 16th February 26. Again, same content, reference to the application number 452 and the same request made. Then please come to page 15, I believe it should be. That will be letter dated 23rd February. Again, similar reference, same request made. Then again at page number 17, reference to all the earlier letters, and then same request made. So this is their consistent stand. Now let us look at the stand taken by MS Pran. Please come to the reply to this IA. And please come to page number 16, annexure R2. 15th April 2026. Does your lordship have it?
Yes.
Statement of case for deferment of posting and completion of 2 years tenure in respect of so-and-so is forwarded herewith duly recommended by SR. And early action is solicited, written by one Mr. K.B. Karki and sent to the headquarters. And the officer is IG rank, upper IG and AR. I was posted at AGR, AR now, IGR. Now, Lord, please look at 17. Statement of case is referred to. Now, please come straight away to page number 90. Para number 2. Major Love Kumar was posted in headquarters Inspector General, Assam Rifles by Indian Army so-and-so, posting order dated so-and-so as additional law officer. Accordingly, the officer physically reported to headquarters Inspector General, Assam Rifles on 20th September and after attending his mandatory judge advocate advance course. His normal tenure of 2 years per policy will be completed in the month of September 26. At present, he stands posted as additional officer, headquarters 86th Infantry Brigade, Western Command by Indian Army so-and-so, dated 1st April on arrival of relief. SS so-and-so has been performing his duty diligently and in an exemplary manner, which has led to significant reduction in pending of files cases received with his headquarters for vetting and advice. Continuity of the officer in the present appointment is of utmost importance for effective handling of disciplinary cases, legal matters and files, especially requiring specific legal advice. In view of the in-depth understanding of the officer and Assam Rifles rules, regulations, policies, and ongoing court of inquiry cases, it is proposed that the posting of Major Love Kumar as additional officer be deferred till completion of his normal posting for 2 years as per policy. Then again, detailed justification is given. Para 4 and 5 is important. The officer was not physically available to perform his Sorry. There seemed to be on some signal glitch at the time. Yes. Yes, now, Lord, I was at that point where I had shown, where I was showing the lordship.
You are referring to paragraph 3.
Yes, Lord. Yes, Lord. Of the statement, Lord. Kindly just come to that.
Yes.
But I'd shown you para 3 of the proposal. I'm sorry, I'd gone on till para 7, not realizing your lordship was not on the screen. My apologies. Now, Lord, para 3 talks about how he's been performing his duty diligently in exemplary manner, led to significant reduction in pendency of file cases received at this headquarters for written and legal advice. This continuity of the officer in the present appointment is of utmost importance for effective handling of discipline, legal matters and files. In view of the in-depth understanding of the officer of Army and Assam Rules Rifles and ongoing code of inquiry, it is proposed that the posting of so-and-so as ALO be deferred till completion of his normal posting of 10 years as per policy. Policy is mentioned, deferment is sought, this is their own, and then there's a detailed justification in para 5. Even in the period I was not available, 19th April to 17th, 20, I have dealt with the files in Delhi. I was on temporary duty in Delhi, but I dealt with files. And then kindly just note, para 7, when the officer was on temporary duty at 5 Rajput Battalion, Delhi, he actively participated in the idea and innovation activities carried out in battalion. During and after Operation Sindoor, the efforts and contributions have been duly appreciated by 5 Rajput Battalion by a separate DO letter addressed to this headquarters. Officer has conducted law capsules for sector headquarters under command units where he's delivered lectures on correct legal procedures to be adopted in dealing with disciplinary legal matters. For the same, commanders have appreciated their detailed and sincere efforts. So all of this goes on. And then he mentions about the court of inquiry being stayed. I don't want to trouble your lordship with that. Para 15 is crucial. Para 14, the complexity, first 14, and peculiar nature of Assam Rifles Act rules, policies require the law officer who is well conversant and familiarized with handling issues of Assam Rifles which are involved in ongoing pending matters. Deferment of present posting and permitting him to complete his viable tenure of 2 years would be in organizational interest and ensure seamless continuity. 15, there will be no financial effects as to deferment of posting till completion of tenure of 2 years. In respect of Major Lav Kumar, law officer of his headquarters will be done in organizational interest, and then talks about high degree of, and signed by Mr. K.V. Karki, Officer SO1. Recommendations of the officer strongly recommended. Kindly note, it goes to Manish Pandey, Lieutenant Colonel, etc. Now, Lord, see page number 22, 18 June, under para 2. Undersigned is vetted all legal filed by your letter so-and-so. The same were forwarded on a sigma from time. Further original files who signed notings have been handed over to Rifleman Anil for further handling cover at headquarters IGR North. Then, Lord, 14 July, similar letter para 2. Files taken, done. And I don't want to bulk up the matter for no purpose. Now, let me come back to my submission. This was what I have been doing, and this is what has been happening. Now, I also wanted to show your lordship, Lord, that this letter, this proposal of 15th April is post the 1st of April order of Madam, now proposed respond number 3, and it makes out a case for deferment of my transfer. Later, they finding that they're in a contradictory position, they decided to withdraw from this. Now, I must also bring to your lordship's notice, Lord, that this letter came to me because at page number 16 bottom, just come to page 16 bottom, it was marked for, it was sent to, copy to Military Secretary's Branch, Integrated Headquarters of MOD, Army South Block, and Law Branch Internal for information of the officer, please. So it was marked to me. That is how I got possession of this letter. Now they may choose to withdraw it later, but this is their recorded stand. The question is, can they approve it or reprobate? Can they keep changing stands? My respectful submission is that is not permitted in law. The rule of equity is clear. You cannot reprobate and reprobate. The law is clear. I'll just show you one judgment on that. Before I do that, let me show you the stand of MS Branch once. the stand of MS branch will be at, just give me a moment. Please see. Please see the IA file for vacating of stay. IA number 74 by MS branch. They have not filed any response. This is all they have filed, so I can only go by this. Please come to para 15 of this.
Yes.
Lord, please see. Petition. Please come to para 14 first, not 15 at internal page 12. The reporting of Major Pooja Goyal clearly demonstrates that the impugned posting order dated 1st April was not an isolated or culpable action aimed at the petitioner, but part of a regular chain posting process undertaking in organizational interests. But it is prior to my
Where are you reading? Where are you reading?
It is an IA for vacating of same lot 74 of 26 filed by respondent number 1.
Paragraph?
Paragraph not, please come to paragraph 14 at page 12.
14.
1-4.
Yes.
Yes, sorry, Lord. Before that, I'll place para 8 and 9 also. That this honorable court, while passing interim order, was pleased to record the petitioner had not handed over charge since interim order was passed without effective hearing. Honorable court was pleased to grant liberty to respondents to file an application for modification. 9. Respondents submit that the posting order first has been issued by the competent posting authority in organizational interests as part of routine manpower management. Posting order is neither punitive nor stigmatic and has been issued as a has not been issued as a consequence of any disciplinary proceeding. This is their justification. No reference to the letters of Assam Rifles here that they were asking for a transfer. Posting and transfer orders are normal incidents of service. Petitioner has no vested right to continue at any particular station formation appointment. The petitioner, being an army officer, is liable to serve wherever posted in service interest. I ask myself, you posted me, you allowed me to come, you sent me to Assam Rifles for 2 years. What is the interest, service interest, that I'm being prematurely repatriated, and that too to a place where the court of inquiry and proceedings against me being there, where I've been posted earlier? Then para 11. Petitioner has sought to rely upon the normal tenure rules applicable to army officers and Assam. It is respectfully submitted that such tenure, even if orderly prescribed, cannot be treated as an absolute or inflexible right. Tenure is always subject to operational organizational requirement, availability, and cadre management administration. But please tell us what this was. Should they not tell the court what these requirements are? Or are we to follow the Ipsy Dixie? Nothing at all. Now, Lord, I'll para 14 I mentioned, Lord. Now come to para 15 again. Petitioner's allegation that the new posting has no defined duties, sanction appointment, or administrative necessity is denied. Petitioner has been posted as an additional officer as an administrative measure. Such posting does not amount to suspension, penalty, withdrawal, reduction in status. Duties are assigned to officers as per organizational requirement from time to time. Now, on the one hand, you say, I'm being posted as an additional officer. On the other hand, you say, and you add to that, that the duties will be assigned. R3, on the contrary, gets an assignment, specific assignment and role. I'm being sent as an additional officer, and that too prior to the tenure being completed of 2 years, which completes in September, and in a totally arbitrary manner. And where to be posted in Western Command, where my troubles began, and what is under which is under stay of the Honorable AFT. And then para 16, they try and justify the allocation of duties, a matter of internal administration. If that is the case, why is the posting order of respondent number 3 specific? There has to be some consistency in the stands. Now, Lord, this is all I wanted your Lordship to say. See in this document. Now, let me take your Lordship back to a point which I wanted to make. So we have two contradictory stands. Assam Rifles, which says they want me posted out. I've shown your lordship their letter. Then the 15th April letter, which they suppress, and the notes. Then the then the respondent number one's application at page 10 and 14, saying that the transfer is organizational matter, and there is complete inconsistency in their stands. It is whatever they want to write, wherever they will write it. Is this the standard to be met in a court of law? I ask myself. But that's all I had to say. I'll just show your lordship one judgment on approbate and reprobate and close my arguments. Kindly just see, Lord, Union of India versus Murugesan. This is 2022 2 SCC, page 25. Please hand it over, Major. Major, have you handed over the judgment?
Yes,
Now, Lord, please come to para 26 straight. 26. Approbate and reprobate. This is at internal page 38 of the report. These principles are borrowed from Scott law. They would only mean that no party can be allowed to accept and reject the same thing. Thus, one cannot blow hot and cold. The principle behind the doctrine of election is inbuilt in the concept of approbate and reprobate. Once again, it is a principle of equity coming under the contours of common law. Therefore, he who knows that if he objects to an instrument, he will not get the benefits he wants, cannot be allowed to do so while enjoying the fruits. One cannot take advantage of one part while rejecting. A person cannot be allowed to have benefits of an instrument while questioning the same. Such party has to affirm or discern the transaction. Now, Lord, please come straight away to page para 27.2. Lordship got para 27.2. It begins at page 40.
yes.
It quotes State of Punjab versus Dhanjit Singh Sandhu. Now, please come to quoted para 10 at the bottom. Law does not permit a person to both approbate and reprobate. This principle is based on the doctrine of election, which postulates that no party can accept and reject the same transaction. Person cannot say at one time transaction is valid, thereby obtain advantage to which he would only be entitled on the footing that it is valid, then turn around and say it is void for the purpose of securing some other advantage. Overleaf. The Supreme Court in Rajasthan Industrial Corporation versus Diamond and Gem Development made an observation that a party cannot be permitted to blow hot and cold, fast and loose, or approbate and reprobate, where one knowingly accepts the benefits of a contract or conveyance or an order, is stopped to deny the validity of binding effect of such contract and order. The rule is applied to an equity. However, it must not be applied in a manner as to violate the principles of right and good conscience. And thereafter, not para 27.3, 20 is quoted. So my submission is not, they quote the relevant portions. Now, please come to para 16, quoted at the bottom of page number 41. Thus, it is evident that the doctrine of election is based on rules of estoppel. The principle that one cannot approbate or reprobate is inherited. The doctrines of estoppel by election is one among the species of estoppel in pi, which is a rule of equity. By this law, a person may be precluded by way of his actions or conduct or silence when it is duty from asserting a right which he would have otherwise had. Today, R1 and R2 are both part of the Union of India. On the very same document, they are taking inconsistent stands. R2 takes an inconsistent stand between 15th of April and their later and earlier letters. How can this be permitted? I ask myself. And not if they come up to your lordships and say, all right, we are disowning 15th of April. He could not have got it. One, it was marked to me. Number two, it is your communication. You come for vacation of stay, R1, should you not have placed it? R2 comes for impediment, should not they have placed it? Is this fair and equitable? Is this the job of agencies which are to be fair and equitable, or bodies? Or is it purely and completely malified? Transfer is malified, actions supporting transfer are malified and self-contradictory. That's all not hard to say. Lord, I will, if your lordship permits, I'm not feeling too well. I wanted to conclude this today. I'll take your lordship's leave. Any rejoinder will be made by my colleague in the local court, if your lordship permits me. Grateful. I'll take permission of my learned senior colleague also, if I may leave. My colleague Mihir will be watching. I'm grateful.
You will join for the reply?
Lord, my colleague locally will reply. Lord, I'm not feeling too well.
Okay.
Because there's some, your
Okay.
lordship. If there is something specific, Lord, then if your lordship may accommodate me by one day for the reply, if there's something specific, otherwise he can respond if there is general issues.
Okay. Yes.
Yes, my lord. My lord, from the submissions of the petitioner, my lord, I have noted down 7 points, which I understand I have to rebut 7 points, my lord. And I'll try to rebut them one by one. But the first contention raised was with regard to the jurisdiction of AFT, my lord. My lord, but I don't deny that this honorable court can exercise extraordinary jurisdiction, but if alternative remedies are available, my lord, in my humble submission, your lordship may refuse to invoke extraordinary jurisdiction. Now, I'll place one decision, my lord. Major Goyal will place a decision. This is from Bombay High Court.
I've opened it.
Lordship has this 2023 decision, my lord, Lieutenant Colonel Anjan Kumar Sena versus Union of India.
I've opened it. Yes.
Now, my lord, the facts of this case are more or less identical to the present case, my lord. Here, an officer of army, my lord, was sent on deputation to AFT, Armed Forces Tribunal, on deputation, my lord. And he was sought to be prematurely repatriated to army. My lord. He approached Central Administrative Tribunal. Central Administrative Tribunal held that CAT will not have jurisdiction because he's a person belonging to army, my lord. That order was challenged before the division bench of the Bombay High Court. Now, the Bombay High Court took a view, my lord. But may I just refer to a few paragraphs, my lord, on this. Para 3, my lord, kindly see the facts. May I read, my lord? The relevant facts are required to be noted. The petitioner was appointed in the service of the Indian Army. In response to the office circular dated 19th October 2020, issued by the Armed Forces Tribunal, Principal Bench at New Delhi, he made an application for appointment to the post of Registrar with Armed Forces Tribunal on deputation. Now, my lord, para 5.
Yes.
The petitioner accepted such appointment on deputation by accepting the terms and conditions as set out in the office memorandum communicated his acceptance by his letter dated so and so. It appears that by an order dated 10th May 23, the competent authority thereafter took a decision to prematurely repatriate the petitioner on administrative exigencies to the parent office. Para 6, my lord. Petitioner, being aggrieved by the said order, approached the Central Administrative Tribunal of Mumbai bench and at Mumbai by the original application in question, inter alia, praying that the repatriation order be quashed and set aside. However, the Central Administrative Tribunal rejected the petitioner application, accepting the respondent's objection that the CAT had no jurisdiction, as the petitioner would be governed by the provisions of the Armed Forces Tribunal Act. Now, my lord, kindly come to para 8, my lord. These are 8, 9, 10, 11. There are few paragraphs, my lord. These are the findings of the Bombay High Court, my lord. Para 8, I'll read. May I read?
Yes.
Para 8. Learned counsel for the petitioner is assailing the impugned order would submit that the Central Administrative Tribunal was not correct and justified in dismissing the original application of the petitioner on the ground that Central Administrative Tribunal had no jurisdiction, for the primary reason that the petitioner was posted on a civil post as the Registrar of the Armed Forces Tribunal, although on deputation, it is submitted that for such reason, the cause of the petitioner did not fall within the definition of service matters under Section 3O of the Armed Forces Tribunal Act 2007. In support of such submission, reliance is placed on a decision of the Supreme Court in case of so-and-so, so-and-so. Well, may I skip this part, my lord? Few sentences. Now, para 11, my lord. On a perusal of the order appointing the petitioner as registrar with the Armed Forces Tribunal, it is clear that the petitioner's appointment was on deputation for a period of 3 years. Any appointment on deputation would not bring about the consequence of an extinguishment of the basic employment of the petitioner, which was with the Indian Army. Further, in the petitioner's appointment as the registrar of the Armed Forces Tribunal, there was a clear condition that in case the performance of the petitioner was not found satisfactory during the deputation period with the Armed Forces Tribunal or for administrative exigencies, in public interest, the petitioner would be prematurely repatriated to his parent cadre with the Indian Army. Such appointment and deputation with such conditions was accepted by the petitioner. Now, para 13. In the above circumstances, the petitioner, if was agreed by the improved decision of the repatriation by the order dated 10th May 23, and as confirmed by the Honorable Minister, as informed to the petitioner by the office order dated so-and-so, the remedy for the petitioner being a member of the armed forces would be to approach the Armed Forces Tribunal, considering the provision of Section 14 of the Armed Forces Tribunal Act 2007, which is conferred with the jurisdiction on service matters. Subsection 2 of Section 14 provides that a person agreed by an order pertaining to any service matters may make an application to the tribunal. Section 3O of the Armed Forces Tribunal Act defines service matters to mean, well, one is remuneration, other things. 2, tenure, including commission, appointment, enrollment, provision, confirmation, seniority, training, promotion, reversion. Now, my lord, then there is an exception, para 14, I'll refer to, my lord. On a plain reading of the above definition, we are of the opinion that the case of the deputation would be required to be read to fall in subclause 2 of Section 3O of the Armed Forces Tribunal Act 2007 by applying the rule of existum generis, considering the ingredients of the asset provision, namely tenure, including commission, appointment, enrollment, probation, confirmation, seniority, training, promotion, reversion, premature retirement, superannuation, termination of service, and penal deductions. Alternatively, as deputation is not expressly provided in subclause 2, it can also be considered to be falling in clause 4, which reads any other matter whatsoever. Clause 4 is very wide, which may cover all other residual categories, and the said phrase is to take color from the other 3 enumerations and the main provision of Section 3O of the Armed Forces Tribunal Act, and has to be read as existum generis. The precondition of a matter to be a service matter has to be relating to the conditions of their service as held by the Superintendent Lieutenant Colonel Vijayanath Jha. Insofar as the exceptions which are carved out in Section 3O are concerned, we do not find that the petitioner's case would fall under exceptions which are made for transfer and posting, etc. Thus, in our opinion, the Central Administrative Tribunal by the impugned order has rightly arrived at a conclusion that it had no jurisdiction. So, my lord, this order from the Honorable Bombay High Court, my lord, in my humble submission, has persuasive value, my lord. And deputation will not fall in the exception, my lord. This is a case of deputation and repatriation. This is, and even the petitioner cannot deny this, my lord.
But how do you overcome the submission of Mr. Luthra regarding the exception 2?
Exceptions has been dealt in para 15, my lord. That's why I read para 15, my lord. The Honorable Bombay High Court held that deputation will not come within the definition of transfer and posting.
No, because the question was not before the Bombay High Court as to whether the Armed Forces Tribunal had jurisdiction or not. It was referring to the what do you call, the order of the CAT.
Yes, the issue was whether CAT will have jurisdiction or not, my lord. CAT has held that it has no jurisdiction. Matter was taken to High Court, my lord. High Court upheld that CAT has no jurisdiction, my lord. May I just once again refer to para 6, my lord, in the same judgment, my lord.
Yes.
Because para 6, if I may read, my lord, the petitioner being aggrieved by the said order approached the Central Administrative Tribunal Mumbai bench at Mumbai by the original application in question, Inter alia, praying that the repatriation order be quashed and satisfied. However, the Central Administrative Tribunal rejected the petitioner application, accepting the respondent's objection that the Central Administrative Tribunal had no jurisdiction, as the petitioner would be governed by the provisions of Administrative Armed Forces Tribunal Act. So, the issue before the Bombay High Court was whether CAT will have jurisdiction or AFT will have jurisdiction.
Yes.
So that is my first rebuttal to my lord. The first objection raised with them. The deputation would not fall in the exception. Now, the second submission that has been made, my lord, is with regard to the normal tenure of 2 years, my lord. And they refer to page 69 of the writ petition. Now, my lord, in my Miss IA number 72,
of the writ petition.
my lord, my IA is 72, which was filed with implement and vacating the interim order, my lord. That is registered as IA number 72.
72.
72.
Page number?
Page number 10, my lord.
Yes.
Well, this was a clarification given with regard to, but otherwise also this, even this is not necessary because the guidelines with regard to transfer and posting, my lord, those are only directory. That is a very well settled position in law. Now, kindly see, moreover, furthermore, my lord, the government has, the department has issued a clarification. Para 2, I'll read, my lord, in this. This is referring to posting policy. Aspects pertaining to the exposure in various appointment areas are given in Appendix A. However, duration of tenure given in the appendix will only serve as a guideline. The tenures may be extended or curtailed in a service interest where necessary.
Yes.
So, my lord, my second submission is that these are only directory, my lord. These guidelines can never be mandatory, and no rights will flow out of these guidelines in warranting any interference with this honorable court, my lord. That's 2, my lord. The third submission that is raised was with regard to non-traverse, doctrine of non-traverse. Now, the doctrine of non-traverse in my humble submission will come into picture where any factual assertion has not been rebutted or denied, my lord. In this case, my lord, we already filed our IA, my lord, and where we have stated our stand and the relevant facts which we thought are necessary for adjudication of this matter. So this, in my humble submission, is not a case for invocation of doctrine of non-traverse.
Yes.
But the fourth submission was made with regard to some social media circulation, my lord, where Damadji and other words have been used. Now, my lord, kindly see those social media publications, my lord. Those are shared by one Colonel Mukul. Colonel Mukul. He is a retired army officer, my lord. So being a retired army officer, my lord, he has no control over any disciplinary matter over the petitioner, my lord. He is simply a busybody. So the picture that is sort of painted that the petitioner is being transferred to a place where Colonel Mukul will have some kind of influence or control over any inquiry proceedings going against the petitioner, my lord. That is incorrect, my lord. He is a retired officer of the army.
Yes.
Number the fifth and most important submission that was made is with regard to consistencies in IA number 72 filed by Assam Rifles, my lord, and in IA number 74 filed by the MS branch, my lord.
Yes.
Now, Lordship has seen the petitioner was deputed to Assam Rifle on 5/8/24, my lord, 5th August 24. He joined on 30/9/24, 30th September 24, my lord.
Yes.
The first letter we wrote to the Army Integrated Headquarters, my lord, that is dated 17/6/25.
Where is that?
But that you also will find with IF 72, my lord.
Page?
Page 11 of IA 72, my lord. Page 11, your lordship.
Yes.
So 17 June 25, first time you wrote, my lord, to the Integrated Army Headquarters, my lord, that please give some other officer because we are having difficulty. Our disciplinary work and legal work is severely impeded because of his continued absence. Now, my lord, kindly correlate the dates, my lord. He joined on 30th September 24. First letter we write something around 8 or 9 months after his joining, my lord. But Integrated Headquarters did not act immediately on that day. Integrated Headquarters waited for another 10 months, my lord. After that, when he was about to complete his tenure, my lord, 24 is the stated tenure, my lord. Now he is 21 months now, my lord. So Army Headquarters, so there is, in my humble submission, there is no inconsistency, though it was initiated by us, my lord. But Army Headquarters acted only when the time came for routine transfer, my lord. Because 24 months he'll complete in August, my lord. We are now in the month of May. At that time it was month of April, my lord. So when he came within the range of 20 months, my lord, Army Headquarters then only as a matter of routine transfer. Well, routine transfer doesn't mean routine transfer takes into account, my lord, inefficiencies of some people, or there are some deadwoods in the department, my lord. There are some complaints against some departments. Routine transfer definitely can take into account that. But as long as he is transferred and posted or deputed to an equivalent post, my lord, with the same pay scale in the desired rank, my lord, that cannot be only because there are some communication.
No, Mr. Luthra has shown that he has gone to a assigned duty. He is not absent. If the petitioner is on assigned duty at Delhi, he can't be said to be absent. Can you mark him absent to a person who is sent on duty?
But he's attending court of inquiry in army area, his own court of inquiry. That's what my instruction is, my lord.
But Mr. Luthra read that letter.
Because court of inquiry is initiated against the petitioner, my lord. And that is the subject matter before AFT. He has already approached AFT with regard to that, my lord.
But Mr. Luthra read that letter. He was on duty.
Well, this was the letter Mr. Luthra read, my lord. Now, there's another statement of case, my lord. I'll come to that, my lord, on the next point, my lord. There is a 2 or 3 page recommendation submitted.
Yes.
My lord, I think your lordship is referring to that. my
Yes,
lord.
recommendation that to keep him
My
here.
lord, my lord, I'll address that, my lord, as the next point, my lord. So, my lord, I was only addressing this point that there's, in my humble submission, there's no inconsistency, my lord. Since the time we started writing in the month of July,
No, he
25, my lord.
15/4/2026 letter.
Yes, I'll come to that. That I've enumerated as the next point, my lord. I'll address that. Right now, I'm only trying to address, my lord, the inconsistencies, the claimed inconsistency in the 2 affidavits, my lord, in IA number 72 and IA number 74. So I'm trying to submit, my lord, that there is no inconsistency, my lord. Assam Rifle wrote to Army headquarters to please give a replacement because we are facing difficulty because of his continued absence. But it's not that Army headquarters took action immediately, my lord. Army headquarters waited till such time the routine transfer became due.
But please tell me,
Yes, my lord.
is it a case where the absence is unauthorized?
My lord, absence unauthorized is not a case of unauthorized absence, my lord. It is a case that because of the absence from the office, my lord.
No, let me say
Yes, my lord.
that a person in any service, he applies for leave,
Yes, my lord.
he is granted leave.
Yes, my lord.
After being granted leave, can somebody come and say that because he's on leave, the work is hampered?
My lord, kindly see, my lord, 17 June 25, when we wrote this letter, my lord, there the period of absence is very small, my lord, 17th February to 20th February.
Okay, he was absent, but he's not unauthorizedly absent.
Not unauthorized, my lord, it will entail very serious disciplinary action.
Service jurisprudence, somebody say that well, we granted him leave, but because of his absence, we are suffering.
Well, that can be situation, my lord. Say, for example, I'll give you, if I may give an example of a university, my lord. A teacher goes on leave, my lord, for 3 months or 2 months.
Yes, it's permissible. 2-year leave is permissible.
It is permissible, my lord, but then the faculty, my lord, is entitled to write to the administration, my lord, that please give a replacement for 3 months or 6 months.
No, we don't know. Replacement is something whether the petitioner or the respondent, the petitioner has a choice. That okay, I am going, you appoint ABC in my place.
Yes,
or I am going for my marriage. Please appoint D in my place. Can he, while a person taking leave, suggest who is to be?
No, my lord, we are not asking him to suggest, my lord. We are writing to our head office, my lord. That please, because your lordship will see page 11, the 17th June letter is to the integrated headquarters, my lord.
Okay. Okay. Point taken.
But so, my lord, that is my submission in this regard, my lord. There is no inconsistency. No immediate action was taken. The integrated headquarters waited till the time he comes within the range of 21 months, my lord. Though we started writing immediately when he completed nine months of service only on deputation. So it cannot be said, my lord, there is a very stark inconsistencies between the stand of MS branch or headquarters on rifles, my lord. Number the next point is with regard to the statement of case, my lord. Mr. Luthra was referring to a letter, my lord, post transfer order.
You're referring to which page?
I'm referring to their reply to IA number 72, my lord. The petitioner's reply to IA number 72. Page 19 of that.
Yes.
My lord, page 18, you'll also will see the date, my lord. 15th of April 26.
Yes.
And the previous page, my lord, page 16, you'll also will see. Now the statement of case is forwarded by whom to whom, my lord? This is slightly relevant here, my lord. This statement of claim is forwarded by IGAR North, my lord, of Assam Rifles to headquarter Assam Rifles, Shillong, my lord. On 15th of April, the IGR is writing to headquarter Assam Rifle, my lord. Immediately on seeing this, my lord, Major Puja will produce two letters, and it is in their knowledge because Mr. Luthra was also referring to these two letters, my lord. One is dated 18th April and one is dated 20th April. Kindly see the second one, my lord, 20th April 26.
Just a moment. Also is 20th April. I read para 2 and 3. Right? The statement of case, my lord, was cancelled, recalled by the headquarter, my lord, on the ground that it is by an incompetent person and without following the proper channel. My lord, this statement of claim case, my lord, if I may submit, is orchestrated by the petitioner because he is there in IGR North. There's something that can't be understood. What does it mean? This contents of the letter.
Well, it says, paragraph, if I may just read it, my lord. When that we received at the headquarters, my lord, at Shillong, when we received that statement of claim, my lord, from the IGR, Kohima, my lord, because IGR Kohima, Lord was seen, also forwarded a copy directly to IHT, Integrated Headquarters of Army, my lord. So, my lord, the whole purport of this letter is, my lord, that IGR is not the proper channel, my lord. All this recommendation or statement of claim have to be forwarded through the head Director General of Assam Rifle, not at the level of Inspector General of Assam Rifles.
Yes.
Now, my lord, as I stated yesterday also, my lord, the relieving officer is joined, my lord. And against one post, my lord, we are having two officers right now. And there's an interim order operating, my lord. We are not able to hand over the charge to the relieving officer.
That you have submitted yesterday.
Yes, my lord. And my lord, lastly, I'll submit the scope of inquiry, my lord, under 226, even if your lordship entertains the writ petition, my lord. Though my submission is that they should approach AFT, because they're also taking the shelter of AFT's order, my lord. Your lordship is seeing. Yesterday I submitted, my lord. They're taking shelter of one AFT's order, my lord, to say that he has to be posted at Kohima to appear before the AFT or court of inquiry virtually, my lord. My lord, that is simply a permission given to him by court, my lord, that you can appear virtually. That doesn't mean that you cannot be transferred out from this place, my lord. Now, my lord, your lordship is aware, my lord, the scope of interference in transfer matter or deputation matters, my lord. If lordship desires, I can place one short decision on that, my lord. If Major Goel can give Major General J.K. Bansal's case a copy of to your lordship.
Yes.
Well, I'll refer to para 8 till 12, my lord. 8, 9, 10, 11, and 12.
Yes.
Well, para 8, it only lays down the background, my lord. Para 9, they've quoted Silpi Bose persisted of PR. It's a famous decision. Para 10, they've quoted S.L. Abbas, my lord. It's a famous case. Para 11 against Sri Bhagwan's case, my lord. Para 12, my lord. I just wanted to read one line, my lord. It will be noticed that these decisions have been rendered in the case of a civilian employees or those who are working in public sector undertakings. The scope of interference by the courts in regard to members of armed forces is far more limited and narrow. So, my lord, what the proposition is laid down that even in case of civilian employees also, the scope of inquiry or scope of interference is limited, my lord. In case of armed forces, is even more limited.
Yes.
So, my lord, that is my submission, my lord. I try to revert the points one by one, my lord. And only one concluding submission, my lord, in 226, your lordship will not enter into roving inquiry, my lord. What will prima facie, your lordship will see with, and the malafide they have alleged, my lord, in the writ petition in every paragraph, my lord. But against whom, my lord? Malafide against Pooja Goel, Major Pooja Goel cannot be, my lord. She has come from somewhere else. But to plead malafide is very easy, my lord. To prove malafide is equally difficult, my lord. And there is no material in this case that there is any malafide. They are trying to bring malafide against one Colonel Mukul, my lord, who is a retired officer.
Yes.
So I'll conclude that, my lord. Jain Melods.
That's all, I suppose.
Yes, madam. We conclude the hearing.
Yes.
Before Lordship, my family consider I 72 and I which is by before you did me. So whether actually ask my will be to this.
We'll pass a consolidated order
So it is order was
because we'll pass a consolidated order. All the orders will be released together.
Yes.
Lord, I'm sorry, I came back, I took some medicine, I'm sorry. May I have 2 minutes, Lord, if your Lordship permits, to rejoin?
Yes, yes.
Lord, my learned senior on the opposite side for the Assam Rifles says that your Lordship's power under 226 is curtailed. I don't think that's the correct exposition of the law. With greatest regard to him and his learning, the issue is today, I am not asking your Lordship to go and seek trial or to carry out a trial or it's an original proceeding. The issue that we really asked your Lordship to see is see the order based on admitted documents and pleadings. The admitted documents and pleadings speak for themselves. Now that's and today, I must say this, Lord, it is unique that you have two respondents before your Lordship. One is the Assam Rifles, one is the respondent number 1. Neither of them have taken the opportunity to respond to your Lordship's summons in this writ by filing a reply. The record of the transfer has also not been put on record. If this is their approach, I ask myself, can they argue things which they have not put on paper on a sworn affidavit? Because your Lordship is to rely on affidavits. Taking my learned senior or Assam Rifles arguments further, assuming that I accepted that your Lordship does not have to go into a forensic analysis, then please accept my pleading on non-traverse and allow the writ petition. That's the first point. It does not lie with any of them to say that they will not file a reply and yet ask your Lordship on their oral ipsi dixi to decide the matter against me, number 1. Number 2, the judgment of the Bombay High Court, that portion is completely arbiter, and I must point that out. I'll come back to that in a moment. But more than that, before I go further, I want this court to see that here are two parties taking self-contradictory stands, internally contradictory and inter se contradictory, and then telling your Lordships, don't allow the writ petition. Or my client not a service of officer, a man of disciplined force, I would say it's a case of perjury. But we don't want to go that far because the idea is the man wants to serve. And his writ petition, I'm sorry to say, but on the other side, they've not looked at the prayers. My writ petition is not as if I have a tenure which will continue for as long as I desire or I want only to be posted at Kohima. My request is this, either let me complete my posting here because you posted me here till September 26. Alternatively, in prayer C, send me to a place. And I ask myself, how can the Assam Rifles have an objection to prayer C? That is the reason the union is not filing an affidavit. Even if they insist on transfer, your Lordship, the only issue was not to be posted in Western Command. Heavens will not fall if I'm not posted in Western Command. Knowing that I've been posted there earlier. Now, Lord, every time I went on leave, why did I go on leave? I went on leave because I was asked to be there for a purpose. When I went on leave, it was sanctioned here. I've shown your Lordship's communications where I've done the work there. No response to that. Kindly note, Lord, I came back in October of 25. November of 25, they are writing letters saying, please send him out, please send him out. November of 25, February of 26, again, three letters of February of 26, one of March 26. 29th October, EFT stayed, I came back. Since then, I've been working diligently. Has my friend been able to show any lack of diligence in the work that I've done? Nothing. No averment to that effect. We can't have a situation, Lord, where disciplined forces act with indiscipline and treat their own officers in a manner which is unknown to law. That is the reason for this writ. Now, Lord, let me show your Lordship that letter. The 15th April letter for a moment. Which is that letter showed to me? The letter. Oh, that letter they shown, the recall of the 15th April. Just let's read it together because I was also trying to understand. I've just dropped what it meant. Let us read it together. Statement of, this is written by Sani Virg Sahab, Colonel. He's the Colonel for IGNR. Statement of case for deferment of posting and completion of 2 years tenure. Refer the forwarding letter. This headquarter letter number so-and-so of 15th April. This headquarter letter of so-and-so. Kindly note the date of this. Please see the date. 5th of May 2026. So, when I came before this tribunal, the letter existed. 24th of April. On 28th of April existed. On 5th of May, and I believe today is the date of 5th of May. Today, they have revoked the letter. And see the reasons. Para 2. Major Love Kumar ALO has personally approached IGR repeatedly and requested to take up for a case for his deferment of posting. Am I not entitled to do that? Based on his personal request, SNC, statement of case for deferment and completion, was processed by branch. So it was processed by your branch. For deferment of posting and completion of 2 years tenure was processed by branch, duly approved by IG, Inspector General ARN. However, the SNC was cancelled right so-and-so on 18th April. All right. The SNC was cancelled. Please show the 18th April communication. Let's see it in a moment. The SFC was cancelled because the case for sidestepping posting of Love Kumar was taken up by headquarters in June 25. Same was not considered while processing is CNC due to turnovers, absence of staff officers well conversant with the case. Major Love Kumar is also never mentioned about the earlier case to IGNR during personal interaction or while preparing SNC. In addition, the officer created agency processed the case by hand for seeking. Did I process the case by hand? I don't understand where they get this from. And the point is, you cancel this on 18th of April. All right. Are you disputing that the contents stated there about my competence and my efficiency and my work are untrue? Your only case is because deferment was being before 1 year ago, there was a case for transfer, and that was prior to the period during the period I was in Delhi. Thereafter, I come back and I serve for 5 months, and you're quiet. Now, let me show the other letter. Let us just see the 18th of April letter. And all of this is happening without affidavits. And then I'm told that the rate ought to be decided against me. Now, Lord, let's see the 20th of April letter. It is intimated that the statement of case for deferment of posting and completion has been held forward to this director with copy and so on. So it is pertinent to mention that formations and units in AR under direct admin control of DG and all administrative comes to inclusive request for posting in tenure are to be processed through MS branch in high headquarters for approval of DG AR. Hence, it is requested that no action be taken on the statement of case submitted by HQR for deferment of posting. See that line. No action be taken on the statement of case submitted by headquarters IGNR for deferment of posting. And kindly just note what was the earlier letter saying? Just a moment. Okay. Just give me a minute. The earlier letters, the subsequent letter of 5th of May says, to your lordship, at para 3, SNC was cancelled. But that is not what 20th of April says. So therefore, even within their own content, they are making inaccurate and incomplete statements. I ask myself, Lord,
Appears-
and now, I'm sorry,
Appears
Lord,
appears to be so. Appears to be so.
appears to be something. I'm sorry. Lord. Now, Lord, therefore, my respectful submission to your lordship is, you can't keep, if somebody is muddying the waters, it's not me. And therefore, Lord, I will respectfully submit, Lord, please consider the writ petition. Please allow it. It is, if an officer today, if they ask your lordship to hold that policies ought not to be given effect to their own internal policies, they are bound by them. And if they want to do something extraordinary contrary to their own policy, then they must come out with a case which they've not been able to. No reason is given to your lordship for deviation of the policy because they have no reason. Now, Lord, let me just show that Bombay High Court judgment. First of all, Lord, it is the Bombay High Court judgment not binding on your lordships in all. It's it as the most instructive, but no more. Now, Lord, please just see para 14 of that judgment. No, first let me show one para and facts. Just a moment. Please come, Justice.
My Lord,
Para
I'm seeking a small apology, my Lord. Now, the Bombay High Court decision, I've been told, my Lord, what I've been told, that some SLP has been preferred against that.
So, Lord, I take it my
So,
friend is not.
my Lord, I do not know the final outcome of that SLP, my Lord, because I saw that notice was issued at some point of time.
No,
so,
no, my
Lord,
friend.
my Lord.
So, if my Lord, therefore, we take it that that judgment is to be issued from consideration. I'm not, that's fair of my friend, and I'm grateful for that.
Yes.
I'm very grateful for that.
No,
So,
but
Lord, that ends the,
What is the point you are making, Mr. Luthra?
Lord, in the Bombay High Court judgment, I'll just tell your lordship, just see that judgment for a moment, Lord. The point I was only seeking to make was just open it. Lord, if my Lord may just see the facts. By this petition filed under 226, 227 of the Constitution, the petitioner has assailed an order dated so and so by the CAT, because there was an order in CAT in a way whereby the original application has been dismissed on the ground that CAT did not have jurisdiction to entertain the original application. So somebody went wrongly to CAT. They said you can't go to CAT. There's no jurisdiction. Now, the issue was not whether AFT has jurisdiction. Now, Lord, just see. Please see, the operative part of the impugned order reads thus: in view of the above analysis, we conclude that on the grievance of the applicant related to his premature repatriation, his OA cannot be entertained by this tribunal because of want of jurisdiction. Therefore, he may seek redress of his grievance in armed force tribunal or alternatively with the Ministry of Defense. So basically, the CAT said, look, we don't have jurisdiction, the end of the matter. Now, my lord, please note, the gentleman had been posted to the Armed Forces Tribunal. For whatever reason, he didn't. And para 6 records that petitioner being aggrieved by the order approached the CAT. Now, please come to the relevant portion, which is para number 14. Because not 13 is the definition, Lord, of service matters. 14 is on a plain reading of the above definition, whereof the opinion that the case of deputation will be covered to be read to fall in subsection clause 1 of the Armed Forces Tribunal by applying the rule of ejusdem juris, considering the ingredients of the said provision, namely tenure, commission, appointment, enrollment, probation, confirmation, seniority, training, promotion, reversion, etc. Alternatively, as deputation is not expressly provided, it can also be considered to be falling in clause 4, which reads any other matter whatsoever. Clause 4 is very wide, which may cover all other residual categories, and the said phrase is to take color from the other three enumerations and main provisions of 3O, and has to be read as the jusum tenderis. Precondition of matter to be a service matter has to be relating to conditions of service as held by the Supreme Court in Lieutenant Court. Insofar as exceptions are concerned, we do not find Petitioner's case would fall under exceptions which are made out. Thus, in our view, CAT by the impugned order has rightly arrived at a conclusion that it had no jurisdiction. So this is about the jurisdiction of CAT, not about the jurisdiction of the AFT. My learned friend is with respect not, and kindly just see 15 also. He is relying on 15. If he relies on 15, it talks about central administrative tribunal, nothing more, nothing less. So I leave it with your lordship, Lord. I leave it with your lordship. I'm grateful for your lordship's consideration, Lord. And my note is already with your lordship, Lord. The judgments which are referred to in the note, one or two other judgments, Lord, the officer will, and my colleague there will file it. I'm sorry, Lord, I had to leave at that time. Some personal exigency.
Okay.
My lord, I also conclude with, but only submission, my lord, my apology, because if any SLP has been preferred against this, my lord, I cannot rely on this.
I think my friend is very fair, and I'm very appreciative, and Lord, on my part, is very gracious of him to say so.
Okay.
Lord, there's a rep from MS.
Else, I would have had to bring it up.
There's a rep of MS branch who want to submit before the court, but they are trying to join online. The link is.
No, it has to be routed through the DSGI or the CGSC. He can't be permitted to make statements here. He is represented by the council. Till the council are on record, we will not hear them.
Yes.
We can't allow the council as well as the litigant to make submissions. Both will not have a right of audience. He'll submit, but then we'll erase whatever Dr. Mozika has submitted. He can't be permitted.
Want Dr. Mozika to lose out, Lord. It's been a pleasure to listen to it.
And, how? Because we can't allow the litigant and the council both to argue.
My lord, matter may be concluded, my lord. I think I covered whatever they wanted to say.
We are not adjourning it. Submissions have been made. We are not adjourning it. If we adjourn, we'll defer it, because then I am only here for a week. We'll not take it up.
Lord, no, but today your lordship kept it for hearing. Lord, they knew very well. They were here earlier. They had an opportunity. It's only when your lordship was closing, they went off camera. I don't think the measure is entirely right. They went off camera, and
No, it's not whether he's right or wrong, we don't know, but he won't be permitted to address us.
grateful, Lord. I think it should be closed. And Mr. Mozika has been very.
Yes. Yes.
Lord, I take my opening order on 18th of March as a reliever of the petition. So he was very aware.
Ma'am can speak into the camera. Ma'am, if you can just speak into the phone, into the mic, please, because your voice is coming muffled.
I received my posting orders on 18th of March as a reliever of our petitioner.
Yes.
So he was very well aware that he will very soon receive his posting orders. This posting order.
You received orders when?
18th of March. And the petitioner was posting on 1st of April. 23rd of April, I joined this place. On 24th, the petitioner approaches the court and takes a stay on his post. The petitioner was very well aware that I will be reporting there on 23rd and will be then taking over the charge of additional law officer, and then will take over the appointment and
23rd of March.
April. 23rd of April, I reported at this meeting.
Yes.
So me being the aggrieved party, we are taking stay on the posting. There is no hand in taking over which has been done between us. And this is affecting me, my lord. There will be a gap which will be there in my service record. And after a year, even I have my PC board, which this gap will affect my PC, my permanent commission board.
What is the term you used? Your gap in your?
My service record. Because I have not taken over the charge.
You think that the Union of India would punish you because of the stay order?
No, not still, I have not, I
No,
am just
but
sitting here, I have not.
Please, we take an offense of what you are doing.
I'm sitting here, 23rd, I've joined here, he was sleeping over the posting order, he should have approached before I have reported here. Me and the petitioner, we were in regular contact, I did inform him my reporting date, but 23rd when I reported here, next he approached the court for a stay.
If there is a gap recorded, you can just approach us, even by a postcard. You
Right.
need not come here. You just send a postcard that because of the stay order, you are affected.
Or may not be order but can be done, the officer can be attached anywhere in any of the army formation, not as a spare prayer that we don't want to proceed to his place of posting where he has been posted. He can be attached to any army or formation nearby. One more point I want to bring to the notice of the court is the statement of case. My lord, if you go through the statement of case, all the signatures on the statement of case are by the officers officiating and not by the officer under whom the officer is, not by the immediate officer, by the officer who were officiating. There were 3 officers who have signed it in the officiating capacity.
You write to the authorities to pass an administrative order so that officiating officers can't pass any orders.
And the same, because
But can it be done? Can you refer it to your senior officers that officiating officers will not sign any document,
no,
will not do any work?
officers were not aware that the case has been taken up. or
But then
this-
that's the responsibility of the union government. Let
that
them
is
take.
being-
Let them take.
The statement of case has been cancelled.
If that is so, then the Union of India will take departmental action against them. The government of India will do it. The army is capable enough to punish those who have exceeded their jurisdiction. We won't make any observation of that sort.
But if I may just say one thing in response to ma'am. Madam is aware of this. She's aware of these proceedings. She appears yesterday. She does not seek impleadment. Today, she is now espousing the case of respondent number 1. I was intrigued by her statement that he can be posted wherever he wants. We can post him. Now, who's we? Is the question. She could.
Mr. Luthra, we have to accuse her.
No, not your lordship has to hear her, but she has to decide official capacity yesterday, personal capacity today. No problem. I've also sought her to be impleaded because she's an affected party. But my point is, just as she says, I was sleeping over it, I asked myself, ma'am, respondent number 3, and I can't ask her, but respondent number 3, ma'am, proposed respondent number 3, was well aware why she could have sought an impleadment here.
We won't allow this to.
But
what we can handle.
My lord, I think we can graciously ignore that part.
Mhm. Yes, you were saying something more? That's all. Okay.
That's all, not that's all. Grateful.
Okay.
Deeply obliged.
But Mr. Siddharth Luthra, Senior Counsel, assisted by Mr. M. Joshi and Mr. M. Verdu, Learned Counsel for the petitioner. Also heard Dr. N. Muzika, Learned Senior Counsel, assisted by Ms.
I'll give the name, my lord.
Huh?
I'll pass on the name, my lord.
You give the counsel's name.
Yes, sir.
You're also there with Dr. Muzika? Huh. Along with Mr. Yangaruti, Learned CGSC, appearing for the union respondents. And also heard Major Pooja Goel, who is the relieving officer, present in court. Full stop. The submissions have been concluded, order reserved.
Not my application, which I had filed for them to be impleted.
We'll pass orders together.
Grateful.
You see, Mr. Mozika,
My lord.
if we pass orders in the interlocutory application,
It's
I-
not required, my lord. A composite order will do.
and say that you have a right of response, you file what you call amended writ petition. Mr. Luthra will say that he has to make additional prayers that he also.
Affidavit and rejoinder and so many things will come.
Then-
Yes, I completely agree.
And it goes for next 1 year.
I know,
Yes,
but I
sir.
completely understand. But that's the reason. But in all fairness, what had fallen from my learned friend, Mr. Mozika, I took heed of what my senior had said, and therefore I thought we should correct our path insofar as the parties are concerned.
Yes, we'll take note of that.
Grateful.
But we are avoiding this.
Understood, Lord. Fair. I think it's completely appropriate.
Once we pass an order, it goes beyond our hand.
I
Then you
understand.
have a right of the reply, rejoinder, pleadings.
Yes, of course. Yes, of
Yes,
course.
sir. Yes, sir.
Very true. Very true. I'm deeply obliged, not for the kind consideration and audience.
Deeply.
Thank you.
Thank you.
Yes. Yes. Okay. Don't put a big stapler because I have to take it out. Let my notes are there. Give a small stapler, or just keep it like that only. Don't.
Admission, item number 1.
Yes.
Here. Yeah, 43 petitions, lordship. So out of which, 3 has been regularized, lordship. So the case of 10 of them is still under process, lordship, but out of which 1 of them, lordship, he has served only for 3 years, lordship. So it cannot be covered by the OE.
Just a moment. Here, there are 43 petitioners.
Yes, lord.
Out of these 43 petitioners, cases of
33 has been regularized.
one is not eligible. That is serial number, petitioner number?
42.
Yes,
And 9 of them, the case is under process, lordship.
9 is under process.
Yes, lord.
You agreed? If that be so, then you are in the waiting list. We can close this writ petition.
Yes, lordship. And then regarding the petition, your lordship,
She's not eligible now. She
Yes.
will come when her turn comes.
yes, lordship.
But lordship, he has already retired, lordship.
Oh, acha.
42, lordship.
42 is retired.
Yes, lordship.
But still you are also giving benefit to the retired persons also, no? No, not.
Yes, 758 years, so it's not.
Okay,
In that case, lordship, petition number 4 will be esteemed to withdraw from the petition as well.
petition number 1, sorry, 42.
First to
No, for 42, then we say that he will have a right to pursue remedies if otherwise available.
Lordship,
It will not cause prejudice to petitioner 42.
Lordship.
Okay. Your name is Mr. Walling.
Lordship.
Heard Mr. S. Walling, learned counsel for the, please write it. We may make a mistake. We both are liable,
That's the one.
susceptible to make a mistake. Learned counsel for the petitioners. Next paragraph. You are Miss S. Chang.
Yes.
Ms. S. Chang, learned government advocate, has submitted that as per instructions received by her, out of 43 petitioners, the cases of 33 petitioners have been considered and their services have been regularized. Full stop. Those petitioners are petitioner number.
One.
Just give it in writing. So we'll not make a mistake. Huh? Petition number so and so. Full stop. It is further submitted that as per her instructions, petitioner number 42, give her name also, Sri Yaban K, Yaban K, has superannuated in the meanwhile, and as he has rendered service of only how many years? 28 years.
Yes, sir.
He, on the date of his superannuation, he was not entitled for regularization of service under the policy in force. Full stop. In respect of the remaining 9 petitioners, being petitioner numbers so and so, whatever is left out, their cases are in the wait list and they will be processed as and when their turn comes. Full stop. Next paragraph. As there is no disagreement at the bar on the submissions made by the learned government advocate, insofar as the 33 hereinbefore referred regularized petitioners are concerned, as they have got the desired relief, the repetition has become infructuous in respect of those 33 regularized petitioners. Full stop. In respect of the petition number 42 and 9 other petitioners, petitioner numbers so and so are concerned, the petitioner number 42 shall have right to pursue such remedies as he may be so advised to claim any relief in respect of him. And in respect of the other 9 petitioners, as their cases are under consideration in the wait list, they would have right to renew their to make representations before the concerned authorities as and when they become entitled to be considered for regularization of service. Full stop. In respect of the petition number 42 and the other 9 petitioners, petitioner numbers so and so, the disposal of this writ petition is without prejudice to them. Next paragraph. Accordingly, on satisfaction of the cases of 33 regularized petitioners, this matter having become rendered infructuous, is closed with leave granted in respect of petitioner number 42 and petitioner number so and so, as indicated above.
For admission, item numbers 2 to 6.
Before your worship process, I seek a small indulgence. One of the order impugning petitions caused by the DC involves land which were subject matter of two suits. In the suit, I was the defendants in both the suits, and the suit was dismissed. So it was decided in my favor, and the DC has passed this order as a result of disputes of the court as well as the first appellate court. But I have not been made a party in the presentation. I'm not a party in the presentation. The plaintiffs are there, but I'm not a party. I've not been cleared as a.
If they have not filed, if there's any interest in you file an application for impugning.
I just received instruction about a week back. I seek 2 weeks time to file an impugning application in all this place.
2 weeks, those should be overnight.
So.
Once you have instructions, it should be overnight. 2 weeks doesn't sound good for.
Make sure you instructed.
He has a different reputation. Without material, he doesn't even hear. If he has received instructions, that means he is talking of that. We have a long acquaintance. Do it because of week, because this you see the here, Mr. Jamini has made a strong point. That is why we don't want to give a long adjournment. Here, what has happened, the steps taken, he has been able to demonstrate that the orders which are passed, impugn order which are passed, amounts to execution of a decree without any decree being prepared. He had specifically submitted on the last occasion that there was no decree in existence. And therefore, by virtue of this alignment and that, what actually is being done is an execution of a decree. That is impermissible. If anything which Mr. Jamir has said is right, then the procedure adopted is not correct. So that is why we don't intend to give a long adjournment, because it materially affects his right. Unless there's a decree, he can't obviously file a section 47 application or any other application. So that's fine. We give you a week's time to file it and we'll get it listed after 10 days. Give a date after 10 days. And you say, heard Mr. T.V. Jamir, done a counsel for the petitioners in all the connected writ petitions. Next paragraph. Mr. M.T. Longchar, learned counsel enters appearance and submits that he has received instructions from the plaintiffs by the defendants in the two civil suits, being declaratory suit number 6 of 2005 and declaratory suit number 7 of 2025, that this writ petition has been filed without impleading them. So accordingly, he submits that some time be granted to file an interrogatory application for impleadment. Next para. In view of the submissions made by the learned counsel for the petitioners, that the orders under challenge amount to execution of a decree without a decree being prepared, the court is inclined to give a short adjournment for the filing of the interlocutory application, if so advised. Next, the application may be filed within a week from the date of the order. Next, list on, give a date after 10 days. Whatever, after 10 days, give a date. Ah, 15, okay.
For admission, item number 8.
In such matters, I believe few days back I read an order. In similar matters, and other orders have been passed by this court. Is it so? Not in this case, but in similar matters have been passed.
Those matters are for payment plan completion motion. This matter is for rent motion, paying for rent.
For rent.
Reasons.
Is there a document here settling rent between the parties?
This case, the civil there buying the land or the petitioners for daily for the case motion.
No, that's okay. But
No, it's-
I did not get any document where any land has been, any rent has been fixed.
But the state respondents, they are finally affidavit. In fact, both the respondents, they are meeting the professional also. And a fresh survey is also being conducted, which is part of the affidavit filed by the respondents. The position is appealed by the both the respondents.
Okay, both sides are represented. On the prayer made by Mr. Gauhati, learned CGSC, list again on Thursday. Thursday will be 7th. Okay.
Next item is on the announcement.
Same. Okay, same order.
For admission, item number 12.
Pardon me?
The state, they have already filed.
Okay. You see, if what you have stated in your affidavit is correct, then we direct the state to immediately file an FIR against the person who has made the appointment. And that will be done within a week from today. Somebody has made an appointment you say is illegal. And you're not taken any steps against that officer. Why? You drop a disciplinary proceedings and you file an FIR against that officer. Or do you generate a PIMS for him? You have no third alternative.
Yes. Lordship, this matter came to that after the petition was filed, the Lordship. So you should well, the department.
Immediately you should have done it. We'll issue directions as to why what you call disciplinary proceedings should not be drawn up against all persons who are aware of it, including the additional secretary, who knows about this and has not initiated any disciplinary proceedings against the hearing officers. You can't take both things together. If the appointment order is illegal, drop a disciplinary proceedings. We issue a show cause to the chief secretary to respond as to why disciplinary, the court should not issue a direction that disciplinary proceedings should not be drawn up against this additional secretary, as well as all other officers who are aware of it and did not take any steps while denying PIMS to the petitioner. You have not withdrawn that appointment order. Abeyance and withdrawal is two different things. You are keeping an abeyance. Why?
The Lordship, this matter was addressed before the court, so no actions to be taken.
Did we stop you from doing anything adverse to the interest of the petitioner? No, we pass an order to the chief secretary. We impede him as a party, and then we ask him to respond. If you are making an illegal appointment, everybody should go. Either you give benefit to the petitioner or you take away benefit from everybody. Heard Mr. Muazzamid, learned counsel for the petitioner. Also heard Ms. A. Ayami, learned government advocate for the state respondents. Next para, the case of the, in brief, the case of the petitioner is that he applied for a post of driver and in a result declared on 25/5/2023, 9 candidates were declared successful. And consequently, upon recommendation made by the Departmental Recruitment Board, by an office order dated 6/6/2023, the petitioner was appointed to the post of driver grade 2, Roman 2, under the Nagaland Public Works Department. First off, it is projected that though his appointment was confirmed, but the respondent authorities had not generated his PIMS code in terms of OM dated 4/3/2022, and accordingly his salary and other emoluments have been withheld. Agreed by the same, the present date petition has been filed under Article 226 of the Constitution of India. Next paragraph. In this case, the respondent numbers 1 to 5 have filed their affidavit in opposition through one Sri Selichum, CSELICHUM, Thongstar, THONGTSAR, Additional Secretary, Department of Works and Housing, Nagaland. Wherein it has been stated that by letter dated 8/9/2025, the additional secretary to the government of Nagaland had written to the engineering chief, Nagaland Public Works Department to keep the appointment of the petitioner to the post of driver grade 2 in abeyance. Full stop. It is further stated that though the department-wide letter dated 1/6/2023 sought clearance against the additional vacant post of driver, without the clearance, the appointment order of the petitioner, appointment order dated 6/6/2023 in respect of the petitioner was issued by the NPWD against the post vacated by one Sri Chumembo, CHUMBEMO, Lotha, LOTHA, without observing due process of law. Full stop. It is further stated that the department accepts responsibility for the oversight. Full stop. In view of above, it is made to appear before the court that the appointment of the petitioner is illegal. Full stop. If that be so, then the department ought to have either initiated departmental action against all those erring officers who are involved in issuing appointment orders without confirmation from the government, or if they acquiesce such appointment, and by not taking any such adverse steps, all the respondent authorities have acquiesced the appointment of the petitioner to the post of driver post grade 2. And therefore, it was incumbent on part of the state respondents to issue PIMS in favor of the petitioner. Next, accordingly, the court is inclined to implead, to suo motu implead the Chief Secretary to the Government of Nagaland. As the Chief Secretary to the Government of Nagaland is already impleaded as respondent number 1, full stop. We hereby issue a notice to the respondent number 1 to show cause as to why, even after the department finding out that the appointment made in respect of the petitioner was without confirmation, no departmental action has been taken against all those erring officers who are hand in glove with each other for issuing the appointment order dated 6/6/2023 to the in respect of the petitioner. Specifically for flouting the departmental norms and procedures and the OM in force. Full stop. Alternatively, if the departmental action is not being initiated, why the state should not issue a PIMS in respect of the petitioner? Stop. Accordingly, the Chief Secretary of the Government of Assam, Government of Nagaland, is directed to file his affidavit showing cause in terms of this order. Next para, the learned government advocate shall send a downloaded copy of this order requiring the chief secretary to the government of Nagaland to file his affidavit within a period of 4 weeks from the date of the order. Next para, the affidavit shall be filed at least 2 days prior to the next date of listing. Next para, list on today's 5th. So we'll take it on 8th. List on 8/6/2026.
For admission, item number 16.
May it please your lordship.
Yes,
Lordship, I'm appearing on behalf of respondent 2 to 5
yes,
on behalf of Senior Standing Counsel of Income Tax, Mr. S. Chetia.
yes.
Lordship, I'm praying for 3 weeks time to file affidavit, lordship, in this matter.
Okay. Heard Mr. Oseko Patel and counsel for the petitioner. Miss
A. Pradhan.
M. Pradhan, Leonard
A. Pradhan, lordship.
Pradhan, Leonard counsel appears through video conferencing mode on behalf of Mr. S. Chetia, Leonard standing counsel for the income tax. And prays for him is granted 3 weeks time to file her affidavit in, file departmental affidavit in opposition. As well as Vakalatama. Full stop. List after 3 weeks. Okay, interim order passed earlier stands extended till the next date of listing.
A date may be given, lordship.
Give a date after 3 weeks. Just calculate, just do a rough calculation and give a date. You can, don't have to be so meticulous. 2/8,
Yes.
28.
Yes, 28.
Okay, 28/5/2026.
Kindly oblige, lordship.
For admission, item number 17.
Here also it's the same.
Same, okay, same order.
The council is not able. Because on last petition, last date launching, already it's been shipping in 6. Because you direct to take steps. On the.
Okay, but the council left. You did not
Yeah.
say.
But since we are taking.
No, we could have
steps.
passed orders when she was there. Can you connect again? When she was there, you could have addressed us. You waited for so much time that she disconnected. She could have appeared in this
Yeah,
matter.
Maybe they didn't get instructions on that.
No, but that would be their responsibility then.
Yes. Because lordship is connected. Because
Yes, lordship. So sorry, lordship.
Yes, you are not appearing in this next item, item.
Lordship, in item 17 also, lordship, I'm appearing on behalf of respondent 2 to 5.
Okay, 17 also. Okay, same order.
Yes, lordship.
really,
Same order.
Yes.
same thing.
Highly obliged, lordship.
For admission, item number 22.
Lordship, I started by this honorable lordship.
steps upon Respondent number 7 has to be taken by way of newspaper publication on 19/04/2026.
Where is that?
According to the compliance certificate, there was already by motion. Was filed on 20/04/2026. So the notice from all the respondents due to complete motion.
Just wait.
Is before the mission hearing.
Just wait.
This lordship, lord, time for respondent number 7, lordship, only this morning we have filed our.
Your respondent number 7 means this person.
Yes.
For whom steps was taken. Okay. Also is represented pursuant to newspaper publication of summons on respondent number 7, comma, the respondent number 7 sent its appearance through Mr. Just write it down. Full stop. The records show that affidavit in opposition has been filed by respondent number 8. Nobody wants to file affidavit?
I have responded number 8, Lordship, I will be fast. Government is also filed on the Lordship. Government is also filed on the.
Government is filed.
Is also filed, Lordship.
Okay, government has filed. So don't say that, last line, don't write. Yes, you want to say anything more? You don't want to file any counter? No, necessary steps is too vague. Tell us, you want to file an affidavit or don't want to file?
Lordship, here the matter is a little bit of urgency where public interest is involved here, Lordship.
But still, he has to file an affidavit.
Lordship, so should give benefit so that parties will make the successful Lordship.
So the prayer made by learned counsel for respondent number 7. 3 weeks time is granted to file affidavit in the matter. It is made clear that if no affidavit is filed within the long time allowed, the matter would be heard on the basis of materials available on record. But please button up your coat. This is something I dislike. Okay, please don't give a date after 3 weeks.
Interim findings.
Okay, interim order past release stands extended till the next date of listing.
Obliged, Lordship.
For admission, item number 32.
Thank you, Mr. Lordship.
Yes,
You should have received the affidavit in opposition filed by respondents. Item 7.
I don't get it. Please repeat again.
I have received the affidavit in opposition filed by respondent number 5 and 7.
5, 6, and 7, we have already rejected that prayer. Unless they file an interrogatory application showing cause, we will not accept it. That affidavit has to be rejected. You better file an IA. You explain the reason for not filing within the time allowed. But there's a judicial order of this court, which has been implemented by order dated 27/4/2026. We have to recall that those two orders. Otherwise, your affidavit will not be taken into board. Okay, all sides are represented. the learned counsel appearing for respondent numbers 5, 6, and 7 submits that an affidavit in opposition has been filed. Next, in this regard, the court is of the considered opinion that as following the order dated 26/3/2026, the prayer seeking time to file affidavit in opposition was rejected by order dated 27/4/2026, till those two orders stand, the affidavit of the respondent numbers 5, 6, and 7 cannot be accepted. Next, accordingly, the learned counsel for the respondent numbers 5, 6, and 7 raised for some reason is granted a week's time to file interlocutory application for to do the needful. Just don't say that. To do the needful. List. Give a date after 10 days. Over.